Please, my lord. My lord, I beg to mention item number 29, ma'am. I am board respondent. What? My lord, since the leading counsel Deep Angin is unable to attend the court due to some personal difficulties. Consent has been taken, ma'am. No, matter may be adjourned for today, my lord. My lord, in here, my lord, the petitioner has challenged the recruitment rule, ma'am. Right, respondent. After vacation, man. I have another mention, man. Item number 41 also. After vacation. Okay.
My lord, I would like to beg to mention item number 24 as the leading counsel is out of the station. And Rama.
What about
Uh,
My name is dear my lord, but brave has been my lord live with this in Rama. So in Rama will lead this.
how long?
after 3 weeks.
Yeah.
My lord, here they have challenged the NIT, my lord. Now, as per our affidavit, my lord, material has been supplied, construction is completed. Basically, this BL has become infructuous, my lord. They challenged the NIT process, and there was no any stay order. Work has been executed, it has been completed. That is the Anyway, my lord, she's asking for 3 weeks time, my lord. Since there is no interim order, my lord, I don't have it.
May Lordship. Lordship, I beg to mention item number 40. Better may be adjourned for today, Lordship. 40. 40.
Why do you want to?
Because Lordship, conducting counsel is engaged in trial court, Lordship. I have taken consent from other side also, Lordship.
No, you're giving preference to the trial court.
No, Lordship.
Should we take recognitions of that? That counsel is more busy in the trial court and is avoiding high court. You should understand the implication of what you're saying. Who's the counsel, Mr. Sonar?
Yes, Lordship.
And the prayer made on behalf of Mr. Sonar.
Lordship, my presence may be reported, Lordship. I am for a respondent number 2.
The matter again after the entry to the application. What is your name?
G. Lordship.
Your Lordship, matter may be taken up on 17 November, Lordship.
Why 7th November?
It's a concern from the other side also.
November.
Lordship, I think, Lordship, amicus curiae is also there. I have no issue, Lordship. Whether it is fixed on 17th also.
Did it come up after the vacation?
Lordship, no issue.
Yes.
Much of it.
Item number 1 to 22.
I pledge your lordship. Well, in last date, the standing council, the health department was supposed to verify whether
Tagum, can it be closed?
My lord, yes, it can be done, my lord. Except, my lord, this, the first item number, it's not a CHG, it's a PHG, my lord. It's written as a CHG Chimpu, my lord, we don't, it's actually PHG, primary health center. Primary health center, my lord. Those certain lacuna, a certain remedial statement, but wherever it's requirement, they can be considered.
But Mr. S. Mao and Mr. T. S. Mao, learned counsel for the petitioners, and Mr. T. Tagum, learned standing counsel, health department. Upon 11/9/2025, court passed the following order. Please abstract it. Next para today, Mr. T. Tagum, learned standing counsel, health department, submits that he has examined the affidavit filed by the petitioner, and that the same is in line with the report submitted by the team of doctors concerned. Start considering the above submission, and upon perusal of the materials available on record, we find that the purpose of the PIL has been served, and accordingly the same is closed. So it is, however, provided herein that the respondent authorities shall put in all efforts to see that all the PHC and CHC are being maintained properly, and the deficits which have been indicated in the report are also addressed appropriately and on priority basis. All the PILs are thus closed.
lordship, may I pray that the deficiency which they have made as per the inspection report, that may be reflected, your lordship may direct that may be fulfill.
I have just mentioned.
It's already mentioned, madam, wherever there's a deficient, madam, they will all, will put all effort to.
My lord, can it be possible as different PHE has got different problems as per the status reports?
No, there are so many PHC and CHCs. Okay, you already have that report.
And so,
Yes.
like,
This order will cover. We have already indicated that the respondents will look into it and address these issues. I have just passed the order. Must have heard it.
Well, unless specific that deficiency is not mentioned, maybe we may not again file contempt. Suppose if they don't implement, then it may be difficulty to again even if you file a contempt, also it will be difficult to address. Your lordship, if it is mentioned clearly of each PHC's deficiencies, then at least we can cross check later stage whether as per your direction, whether they fulfill or not.
No, see, for that purpose, we need not elaborate that in the order.
Yes.
You already have made an affidavit and prepared
Yes.
that format, isn't it?
Yes.
So that they'll have to go by it.
As per on record.
Then your lordship have mentioned that as per our consolidated affidavit, which we have
Based on the
made the deficiencies in that affidavit.
What they said this last
Based
time.
on report submitted by the designated, the committee consists of doctor.
This, however, provided you that that's it, what they said. Deficiency mentioned in the report, filed in the additional affidavit.
Yes.
Mention the report, which is filed by the petitioner in the form of an additional affidavit dated
That is November, your lordship. November 2023.
you don't have a date.
It's November 2024, but the date I'm not able. November 2024.
Need one of the affidavit. Affidavit is a separate file, isn't it? This one. Is it 18 December? You're saying November? This is December.
18 December, yes, please. Appears to be now, 18 December.
In the affidavit, in the rejoinder affidavit filed by the petitioner, dated 18/12/2024.
And then there is also a similar petition was also in the Uttarakhand, your lordship. And then they have also, for the judgment, they have category, they have mentioned the IPGS, how the state government has to follow the IPGS that has been.
Well, that is
in our judgments.
what already at last occasion I have submitted
So,
this.
in fact, the state, they are denying that IPGS not following in the state, but then IPGS, they are following the IPGS because funds are coming as per the IPGS. From the sub-center to primary health center, it has to be upgraded. From the primary health center to community health center, they're getting lots of money to upgrade as per the IPGS.
See, that was not your case the other day. You said that IPHS has not been maintained. The state says, health department says that it's not feasible because of the population ratio. And therefore, we are having our own schemes, our own guidelines. We are following our own guidelines. So to that, you say that, okay, I have prepared a chart and a report as per the visiting, as per the reports made by the team of doctors. So next thing was for Mr. Tagum to examine that. It was never your case that you never insisted that it should be as per the scheme. Although your PIL said that,
Yes,
but your submission was not that. That is why we are closing it.
I agree to that. What
Then-
I want to submit is that IPHS it should be a part of the guideline which they have already formulated. I think, but then they're also part of IPHS. I think they are denying that this is not part of IPHS, but then they are following that memorandum. But then following with the standards. No doubt they have the own OM to say that this is the facilities. No doubt, but then they also follow the IPHS. Because,
But they have their own OM also. They're going by
Yes.
that OM. So
Yes.
that will be strictly followed. And whatever deficit has been mentioned in the affidavit, that will be looked into by them. This is what you're saying. All right.
Obliged.
Item number 23.
Yes, what is this?
Your Honor, respondent number 3 has filed their affidavit.
Hmm?
Respondent number 4, your of 3. Pharmacy Council.
They have not filed.
Oh.
Who's the counsel? Respondent number 3.
Union was appearing for them.
No, who has not filed the affidavit? Who has not filed affidavit?
3 year.
Respondent number 3.
Yes.
Others have filed.
Yes, other only Ministry of Education.
Pharmacy council, anyone appearing? Pharmacy Council of India.
I'm going to respondent number 1 and 2.
Have you filed an affidavit?
Oh, but basically, the respondent number 3 and 4 is the main respondent.
So you have not filed affidavit.
Our affidavit may not be.
You will not be filing. So then who is appearing for 3 and 4?
Your Lordship,
ST Kayal had appeared last time.
for 3, this union has taken the time for filing the affidavit. Your Lordship.
Who?
Union, your Lordship.
For 3.
Yes.
But he's not appearing for 3, he said. 3 is a pharmacy council.
He appeared and filed also one of the affidavit.
What is the issue?
There was one RR, your Lordship, where this MTech and biotechnology with pharmacy degree was not inserted, for which the petitioner had been agreed to be promoted to the HDO post.
Okay. What are challenged here? Some rules you have challenged.
Yes, I have challenged one RR, your Lordship.
Where is that? Page number? Is it page 46?
Yes, 2014 RR, your Lordship.
Who has framed this RR?
Pharmacy Council of India.
So they are the party.
Yes.
They are the main party. 3 and 4.
For this, your Lordship, I have also served the dusty service to them, but they are not appearing.
Have you filed affidavit regarding Dusty?
That's lost. I have filed affidavit.
Who is that? How, whom have you served?
Dusty service has been served on 28 to 25, your Lordship.
To whom have you served?
In their office, your Lordship.
Where is the office?
In Delhi, your Lordship.
Open dark receive.
Yes.
Signature is there.
Appeared by SCKL. Also for the matter respondent number 4. And his name is also not reflected because I'll inform my lord.
Please write down Mr. M. Kato, Lorette DSGI, appearing for respondent number 1 and 2. Submits that respondent number 1 and 2 are basically pro forma respondent and that they will not be filing their affidavit. No one appears for respondent number 3 and 4. It is seen that Mr. S.C. Kayal, Learned Counsel, represents respondent number 4 and an affidavit has been filed by respondent number 4. Just check it up. Is it filed?
Yes, sir.
Affidavit filed? Respondent number 4's affidavit. Maintenance, this is okay. Sometimes there is a separate file, sometimes the affidavit has been filed by respondent number 4 on 19/2/2025. In view of above, further 3 weeks time is granted to respondent number 3 to make appearance. Take fresh steps on respondent number 3.
Yeah.
Then last line, what did they say? Cancel that line. Next line, next para. Respondent number 3 is said to have been served by way of Dasti. On 28/3/2025. What is the date? 28/3 or 28/1?
28/2, Your Honor.
2. Okay, yes. On 28/2/2025. So, however, upon perusal of the affidavit filed by the petitioner regarding Dasti service upon respondent number 3, no particular name has been mentioned except for a signature. Stop. Under the circumstance, the petitioner shall take fresh steps upon respondent number 3 by registered post with ADU within 3 days. Place the matter again after the ensuing puja application, showing the name of Mr. S.C. Kayal as the counsel for respondent number 4 in the cost list.
Item number 25.
This bill is filed challenging the order of the bench. Party alone and party on the ground that actually this initially this writ petitioners filed before the single bench challenging the decision of the deputy commissioner, which is like page number Page number 67, my lord.
63,
67, my lord.
67.
Yes. Wherein being a authority of Deputy Commissioner cum Revenue Officer, decided the title between two private individual, that is petitioner, writ appellant, and art of living. So this was challenged before the single bench, challenging that the Deputy Commissioner cum Revenue Officer has no authority to decide the land as per the judicial notification. Only the judicial authority, the proper court has the authority to decide the title. And
What has the deputy commissioner decided?
Deputy Commissioner decided that is, my lord, that is more particularly in page number 76, that is more visible. On the other hand, as per the order dated 09/05/2025, the complainant party has filed a written statement and exhibited sufficient documents in support of the party has filed written statements and exhibited and their claims, specifically satellite image Google map of the disputed portion of the land, which clearly showing the boundary of CC pillar, which is available in the satellite image, which is evident that the respondent party occupied is under the complaint of LPC land. Hence, the respondent party is occupying the said respective plots of land without any valid authority of law, and the said respective occupied land is under the boundary of above mentioned LPC land of the complainant party. And it is admitted that their respective occupied plot of the respondent, Sri Bengia Talo, I'm the Bengia Talo, and Lindum Tabang is under the complainant's party of the complaint party, and the claiming of the private land by any individual without any valid authorities is illegal and not reasonable in the eye of law. The respondent party, Sri Bengia Law, and Lindum Tagum is hereby directed to vacate the LPC land of Art of Living Society AP Jolang Basti Pagatara Itanagar on or before 080 070821020, failing which the same shall be evicted and restored to the complainant by this office without any notice. In this regard, Guru Podong is strike out from the present complaint case and submission made by the representative of the complainant party. This is the order. So, my lord, my basic contention was that Art of Living is a private individual, it's not a government, and Bengiatalo is a private individual. The two private land, between the two private land, either deputy in the capacity of deputy commissioner or in the capacity of revenue officer, he has no authority to intervene and decide the title, except with the proper court. This was my challenge.
Then what is the order of the senior judge?
Senior judge, my lord, that order is
How, I mean, how it has been decided?
it was decided that the eviction process of eviction is process of page number 183, my lord, I got order. It was decided that the process of eviction is wrong because it is done without any authority. But however, the position of the land having LPC is valid. So the land of the art of the land belong to the Art of Living having LPC should not be interrupted. That was the basic observation made.
Please come to the relevant
It is in paragraph 16, my lord.
16.
Yes, 16, that is page number
Please read.
191.
Read.
Accordingly,
this court is inclined to hold the impugn order dated 16/06/2022 by the eviction order against the petitioner is not sustainable. However, insofar the findings records in the said order is concerned, the same does not want any interference. Thereupon, the party one Deputy Commissioner Capital Complex Itanagar has held the petitioner is illegally occupied the land of the Restaurant Pipe Society. Restaurant Pipe is a art of living. The same is lawful. Apart from that, the impugn order is sustained. Only the part where the direction were issued for eviction of the petitioner as contained in the order that is 16/06/2022 and 09/08/2022, same is held to be not accordance with law. Therefore, in respect to the said part alone of the order is set aside. So chapter in 17 so far as the other part of the impugn order, whereby Deputy Commissioner Capital Complex has directed the petitioner to maintain status quo is affirmed. Accordingly, on violation of the status quo by the petitioner, it would be open to the Deputy Commissioner Capital Complex to take cognizance of such violation, if any, and enforce the part of the order. So my challenge was that not only the process of decision of the title by the Deputy Commissioner is illegal, being a two private lane, but holding LPC by the art of living is also illegal. So per Arunachal Pradesh Land Settlement and Records Act 2012, which is provided clearly provided under section 123, is stating that the only APST is allowed to hold a lane, and non-APST have no rights to hold LPC or allotment in state of Arunachal Pradesh. In Arunachal Pradesh Land Settlement Act and Land Settlement and Record Act 2012, there's no section provided, and even in the court before the learned single bench also, the respondent party has not satisfied the court that there's any provision to hold the land, wherein it was initially a gift that was made by the private respondent to the Art of Living Society, and Art of Living is belongs to is not of its authority is not a APST. If the judgment and order passed by the single bench, under single bench also, no reflection is made that any such privilege, any such right exists to the non-APST. Apart from the decision made that two private land, the Deputy Commissioner or Revenue Officer cannot interfere in the dispute of the two private individuals.
Okay, that aspect of the matter has been dealt with by the learned single judge.
Yes, my lord.
On which paragraph?
The final decision that I have shown you in the and they have not reflected anything as that whether they have the entitled or not entitled. And the paragraph has gone, and even in paragraph 15 it says, paragraph 15 of the same judgment, be that it may be there no substantive provision under the said Act of 2000 empowered Deputy Commissioner to act as a civil court. That also that only refers to the authority to intervene between the two private individuals' land, which empowers Deputy Commissioner as a civil court to entertain proceeding of eviction. In regards, it may be mentioned that the Learned Standing Council for the Land Management Department state under section 79 of the said Act, the Deputy Commissioner is vested with the power to inquiry and decide the arising. So The considering opinion of the court, it is essential empowerment because Deputy Commissioner, thus here also, there, there's no specific, no section mentioned that there's any entitlement to allow the APS, non-APST to hold the LPC or allotment in the state of Arunachal Pradesh. Not even a single authority or a sections which provides has been reflected in the judgment.
What is the act which has been mentioned here? Act of 2000.
2000. In paragraph 15, it says the substantive provision, no substantive provision under the said Act of 2000 which empowers Deputy Commissioner to act as a civil court to entertain proceeding for eviction. In regards, it may be mentioned here that the Eastern Council for the Land Management Department has stated that under Section 79 of the said Act, Deputy Commissioner is vested with the power to inquiry any question decide arising of the determination between the government and any person. That is between the government only, my lord. Parties to proceed shall be a revenue court. The considered opinion of the court that it is essential empowerment because the Deputy Commissioner is the revenue court in exercise of power as a revenue court. The authority is required to pass order with regard to demarcation of the land and also to ascertain the position of the land. As the authority is required to maintain the land records, therefore, mere power of redressal disputes between the party cannot be construed for comfort of power. If there is no specific empowerment under Section 79 or under Section 82 of the said Act of 2000, the court is of considered opinion that so far the disputes are concerned. The revenue court power is to decide whether there was any encroachment. However, the revenue court is not vested with the power under Section 10. This is okay, my lord. The last portion that the LPC land should not be disturbed, which is reflected in the paragraph 16, is the concern. Because in enter judgment, no authority has been reflected that the non-LPST can hold LPC.
No, Section 82, 79 has been mentioned. Where are the sections? Let us see. Arunachal Land Settlement Records Act 2000.
It is only the authority of the revenue officer. I have no dispute regarding the authority of revenue officer that if government land is being encroached, then they have every right to examine the possession.
as a revenue.
You can determine under section 79. One.
And then,
79(1) between the private party and a government.
No, my lord. Yes, that is right, but that not between the two private individual.
demarcation.
That is for the civil court to decide.
What the court has said. Eviction cannot be done. So far as the other part is concerned, that is not interfered. Only the eviction part. Now, the appellant says that revenue officer cannot decide such kind of dispute between private parties.
Yes, my lord.
If one party is government, then only
Yes, my lord. Yes,
decide.
my lord. Exactly.
If both parties are private parties, then civil court should decide.
Yes, my lord.
What do you say on that?
This order only shows that in the heading, this order only shows that this order has been passed under the revenue officer title. Otherwise, you know, the complaint was made before the CEO. Come in. Then after that, so suppose and accordingly they have here for the CEO board and also petitioner could not establish their ownership. But they have not shown any document that shows that they are the owner of the land.
Yes, my lord.
You should notice at this stage, our Mr.
Amnico.
Nico, learned counsel for the appellant submits that by filing this writ appeal, the appellant who was the writ petitioner, correct,
Yes, my lord.
has challenged the judgment and order dated 25/9/2024 passed by the learned civil judge in WPC number 335 of 2022. Stop referring to the impugned judgment and order. The learned counsel submits that the revenue court revenue officer, bracket respondent number 2, under the close bracket Act, 2000 does not have the power to adjudicate land dispute between two private individuals. Therefore, although the order of respondent number 2 was challenged, the learned single judge has accepted the impugn order of respondent number 2 so far as adjudication was concerned, but rejected the contention, but rejected the part of the order by which eviction has been directed. Stop. I grieve the petitioner is before this appellant. I grieve the writ petition is before this court in writ appeal. In this writ appeal, issue notice returnable by 3 weeks. Each Sangeeta, government advocate, accepts notice on behalf of the respondent number 1, 1 to 3. 4 is by name. As government advocate, can you accept without power by name? Sorry, you'll appear or not? Okay. Accept notice on behalf of respondent 1, 2, and 3. Petitioner appellant to take steps for service of notice upon respondent numbers 4, 5, 6, and 7 by registered post with daily 3 days. This matter again after 3 weeks on a date of expiration.
Was obliged.
Item number 26.
Yes.
None of the respondent has filed any affidavit also.
What is the subject matter?
Subject matter, Lordship, here the government of India has sanctioned a scheme for construction of frontier highways, Lordship. And there are 5 villages, frontier villages along the McMahon line, Indo-China border. But the respondent authorities, Lordship, they prefer a road alignment bypassing those villages. Lordship. Those villages had left towards the McMahon line, but they constructed the road alignment, leaving behind all those frontier villages. So, Lordship, the prayer of these villagers that the road alignment has to be passed by passing those villages, touching those villages. It was the grievances.
Yes. Who is appearing? How much time? How much time? And Mr. Kato, you are 1 and 2. 1 and 3. Who's that? Oh,
I'm 4, 7, 8, and 9.
And Lordship, last order 2725, the private respondent number 5 and 6 have been struck out. They are not necessary.
please write. Parties are represented by the respective councils, except for respondent number 5 and 6, whose names have been struck off in terms of the last court's order. Stop having regard to the grievance projected by the petitioner. How many petitioners?
Yes, petitioner.
Petitioners. Appropriate response would be required from the respondent authorities concerned. Accordingly, as paid for 4 weeks' time is granted while counter applicant to all the respondents. This again after 4 weeks.
Apply. Deeply apply.
Item number 27.
To challenge the order passed by the learned single judge here, dated 7/4/2025 in WPC 279 of 24. The writ petition was dismissed basically on the ground of delay in legislation.
Yes, what was your prayer in the writ petition?
Prayer was, of course, for setting aside of my appointment as the AMI, the Agricultural Marketing,
Setting aside of your own appointment.
my lord, of my own.
Why?
My lord, because here, my lord, the petitioners, they were appointed as AFA, basically now VLW, my lord, junior. It has now been renamed as AFA junior.
VLW,
Yes, village level worker in the Department of Agriculture.
renamed as,
And we remained there only. Then
renamed as,
AFA, Agricultural Field Assistant.
so what is your grievance?
Now, my lord, here in the year 2004, my lord, we were just randomly picked, my lord. Now the department is saying that it was based on seniority. We were randomly picked and placed as a AMI, Agriculture Assistant Marketing Inspector. Now that AMI, the post of AMI, till date no RR has been framed, my lord. And from the post of AMI, my lord, there is no promotional post also. Whereas if I was VLW, my lord, in fact, my juniors, they have all promoted to AFS senior also. My lord. They are getting higher base,
VLW was village level worker.
village level worker, redesignated as AFM. From AFA junior to the next promotional post is AFA senior. Now, from AFA junior, my lord, the promotional goes to up to the agriculture development officer. My lord. But these petitioners, my lord, they were just handpicked randomly, my lord, without any opportunity. We were appointed as AMI. And we are still, my lord, getting the same grade pay, my lord, of the AFA junior only. Meaning thereby the grade in which I was appointed, I'll be retiring there only.
You were appointed as AFI,
AFA junior.
AFA junior.
Junior.
So what is your grievance?
Basically, my grievance, my lord, is this regarding the pay only, my lord. Because my juniors, they are already getting higher than my lord. When these petitioners, my lord, being in the post of AMI, my lord, for which, my lord, till date, my lord, no recruitment rules have been framed. Their service conditions have been changed, my lord. That is basically my case. My service conditions could not have been changed like that. My lord knows that the actual promotion or the right to be considered for promotion, my lord, it is a condition of service. Now we have been picked and placed in a post, my lord, where there is no scope of any promotion. Until that, no recruitment rules have been framed. And my pleaded case is, my lord, that since we are already on the verge of retirement, in a few months we will be retiring. That is the petitioner number 1. We are not even claiming for seniority also. We just want some pay. And another aspect is also that the persons who are appointed as AMI in other districts, they are getting higher pay than us. They are getting the same pay as the AFA senior. Now the learned single judge dismissed the writ petition on the grounds of delay in leges and saying that if we are our appointment order of 2004 that is set aside and we are promoted, that would have a cascading effect and inconvenience. It will settle the seniority position also. Whereas
Stand from the beginning. You were appointed as agricultural field assistant.
Madam.
Junior.
well, if,
According to you, you should be appointed as what? AMI.
I should have been promoted to the next higher post of AFS senior.
AFS senior.
Yes.
As per which provision?
Well, it's per the rules only.
Where the rules?
No, rules was it,
What is the criteria?
that I have. If your lordship would come
Is it
to
coming for the first time today? This matter?
no, my lord.
Okay.
It is if I prepared a table also, my lord. It's in page 28, my lord. If your lordship would come.
28.
Yes.
Yes.
Yes. This is the table that I prepared, my lord.
AFS junior.
Yes, AFS senior. It is from the post of AFS junior. 100% by promotion from amongst the AFA junior of the department having 5 years regular service with 2 years training in GTC Pasigan. And from AFA senior, the next post is the statistical officer, which is the promotion for 50% by promotion from amongst the AFA senior.
So it goes on till the
Till
ABCD.
yes, ma'am.
Where's the rules? Have you annexed it?
Yes, I have annexed. It is
Next to 7 series.
yes.
You were appointed in the year 2004,
No, madam. I was appointed in the year 88, madam.
1988.
1988.
And when did you file your writ petition?
It was filed only in the 2024.
Why?
Because, my lord, initially, my lord, the petitioners were not, they were just given appointment. And after that, they have been, of course, these petitioners are serving in remote villages, man.
No, can that be the ground?
I admit, my lord, of course, there's a delay is there, my lord.
Next, what is the series? 7 series. Where is 7?
Seven, it starts at page 49. Man. Is RTR reply, my lord. RTR reply.
Why 7 series has been struck out like that?
My lord.
7 series has been cancelled next year.
My lord, because now in the writ appeal, my lord, this is part of the writ petition itself. So earlier in the writ petition, it was marked as 7 series.
So where is the recruitment rule?
My lord, the AFS senior, my lord, that is said. Sorry. 74.
74.
Page 7.
This is village level worker senior.
My lord, yes, my lord. It has been renamed. my
Or
lord.
renamed. Okay.
Renamed. It was renamed in 2000.
You were appointed randomly in the year 19.
No, I was appointed in the year 1988 in the post of BLW junior man. Now AFA junior man. We underwent the training also, my lord, that is required for promotion to the next post of AFA senior.
And since then you have not been promoted.
No, man. Now 88, after 88, my lord, randomly picked up and appointed as AMI, my lord. Assistant Marketing Inspector.
Who has been randomly picked?
The petitioners, man.
Which year?
2004, man.
Okay. What is the scope of promotion?
No promotion, man. Even for the post of AMI also, man, there is no recruitment rules, man.
So what was the prayer? That he should be placed as AFA senior.
Yes, ma'am. And I have pleaded case of the petitioner. We don't want any seniority. We want at least some financial benefit.
See, the placement of the petitioners or the appellants as AMI in the year 2004
Ma'am.
has been put to challenge by filing your writ petition in the year 2024.
24, ma'am.
So how many years? 20 years.
20 years, ma'am.
How can that be? What is wrong in the judgment then?
My lord,
How can we expect?
my lord, wrong, as in, my lord, that this lordship has relied on this, basically relied on the Shivdas and Tarsem Singh. So,
What does it say? Tarsem Singh?
eight volume 8 SCC 648. Here, Shivdas also has also been relied. Now, if my lord would come to para 6, my lord, at page 651. Para 6. Here, that 2007 6, that Shivdas has also been relied. In Shivdas versus Union the court held so and so. The High Court does not ordinarily permit a belated resort to the extraordinary remedy because it is likely to cause confusion and public inconvenience and bring in its train new injustices. And if writ jurisdiction is exercised after unreasonable delay, it may have the effect of inflicting not only hardship and inconvenience but also injustice on third party. It was pointed out that when writ jurisdiction is involved, unexplained delay coupled with the creation of third-party rights in the meantime is an important factor which also weighs with the High Court in deciding whether or not to exercise such jurisdiction. In case of pension, the course of action actually continues from month to month. That, however, cannot be a ground to overlook delay in filing the petition. Basically, in this Shivdas, which has also been relied by the single judgment, that was a case where the person retired in 1983 and filed for pension only in the year 2005. However, the learned Honorable Apex Court sent it back, basically in that Shivdas also. Paragraph 7, what time? To summarize, normally a belated service-related claim will be rejected on the ground of delay in latches, where remedy is sought by filing a writ petition, or limitation, where remedy is sought by an application to the administrative tribunal. One of the exceptions to the said rules is cases relating to a continuing wrong, where a service-related claim is based on a continuing wrong. Relief can be granted even if there is long delay in seeking remedy, with reference to the date on which the continuing wrong commenced, if such continuing wrong creates a continuing source of injury. But there is an exception to the exception. If the grievance is in respect of any order or administrative action which related to or affected several others also, and if the reopening of the issue would affect the settled rights of third parties, then the claim will not be entertained. For example, if the issue relates to the payment or refixation of pay or pension, relief may be granted in spite of delay. It does not affect the right of third parties. But if the claim involves issues relating to seniority or promotion, etc., affecting others, delay would render the claim stale and doctrine of laches limitation will be applied. Insofar as the consequential relief of recovery or areas for the past period is concerned, the principles relating to recurring successive wrongs will apply. As a consequence, the High Court will restrict the consequential relief relating to areas normally to a period of 3 years prior to the date of filing of the writ petition. So on this ground, it has been rejected that since I am claiming for promotion. But my lord, also, and Learned Singhal just said that it will affect third-party rights also. It will have a cascading effect. But my pleaded case is, I'm not claiming any seniority. It's a pleaded case. I'm saying that they have also hold implement. I'm only retiring in a few months, 2016 middle, 26 middle, I'm retiring. So I don't want any seniority. Just give me some pay.
because wrong has been done to me. We have been randomly picked up, no criteria, nothing, no recruitment rules, how it is to be filled up. They just picked us up, placed in somewhere where we are still getting the salary from the salary of my initial appointment on, still getting the great pay of the AFA junior man. And other issue that I have raised is that our batchmates, our similarly situated persons in other AMIs, my lord, in other districts, say in East Siang district, they are getting the payment of the AFA senior, my lord, which the department has said it's a clerical mistake. But I have been informed, I have the instructions that these persons, my lord, the other EMIs, they are still getting the higher pay, equal to the AFA senior man.
Okay, show us the document by which you have been put as AMI.
AMI.
First of all, where is your initial recruitment?
Initial appointment, my lord, you're supposed to come to annex, page 38. Man. Page 38.
Yes. Where are you? How many petitioners are there?
There are only two petitions.
What they? Where are they?
It is at serial number 26 and 28. Is the petitioner number, appellant number 1.
Then the plan number 2.
And no, 28, man. 26 and 28. Next, at page 42, my lord, we underwent a training also. The order for training, page 42. Page 42, my lord, to the district agriculture officer, so and so, so and so. Deputation of untrained service VLWs for training at GTC Pasig. This is also a requirement, my lord, for promotion to the AFA senior, my lord. And our names are at serial number 25 and 26. Now we remain there, my lord, and this post of AFA, my lord, or VLW, my lord, it was renamed as AFA in the year 2000. Now at page 45, my lord, page 45. On recommendation, DPC services of following assistant marketing inspectors under the Department of Agriculture, who were early appointed on ad hoc basis have been regularized with effect from the date of their joining. As this is a typographical mistake, I believe, madam, because the petition has an AMI on. It says marketing inspector, but it's AM. So the petitioner number 1 is at serial number 6, and petitioner number 2 is at serial number 4. But after that, Malo, since 2010, Malo, that annexer 4, 5, 6, Malo, we have submitted various representations, Malo.
No, where is that? That randomly you have been picked up and posted, placed as agriculture marketing inspector.
Yes, Malo, this is the order.
So, but it says that you are the agriculture marketing inspector,
It's agricultural or assistant marketing inspector.
assistant marketing inspector. Yes.
For this, my lord,
Since when did you become assistant marketing inspector?
2004 only.
So thereafter you kept quiet about it for 20 years.
My lord, not kept quite as such, but we submitted various representations, of course. Those were never attended.
Okay. repeated representations does not furnish press cause of action.
That I agree.
There's a judgment.
That of course I agree. But my claim is based on that. It's a continuing wrong that is happening, man. And
Continuing wrong, maybe.
My
The thing is that we have not approached even the right.
And my lord, I am not seeking any seniority also. I am retiring. I'm just want some pay benefit. Man.
Don't the government of Arunachal Pradesh follow that MSCPS scheme?
Follows.
Then you must be getting that.
Well, but if your lordship would come to me, I will just show the what is the pay I am getting and what's the pay the AFA senior is getting. Just
Of course, senior and junior will have a different pay.
my lord, that's why, man.
They'll have a different pay.
My lord.
But your case is that you have not been promoted for a long time. Now, as an agriculture marketing inspector, is there any recruitment rules
No recruitment.
to promote you?
No, man.
No recruitment rules.
That is, my lord, that,
Then, currently, do they have AFA junior and AFA senior?
yes, my lord.
Posts there.
That post is of course there, my lord. The post is
Agriculture field assistant. Still there.
there, man.
Senior, junior.
Senior engineer is still there.
Your initial appointment was village level worker.
Yes, man. Junior.
Converted
Junior.
into junior. Converted into AFA junior. Where's the conversion?
That, my lord, if your lordship would come to,
You said in the year 2000 you were converted.
yes, page 50, my lord.
The post.
If, I do not have the order, my lord, but I have the information under the RTI, man. At page 50, man.
Yes.
At the serial number 1, man. Furnished order by which the post of so and so, so and so. The post of village level worker was redesignated at AFA, so and so, with order number so. This is at page 51 is the order, man. List order redesignation of the polling post. At page 51, it's the order. Now, if your lordship would see the serial number 3 of the same RTI also. Page 51 is the order of redesignation. Type copy set page 52. At page 50, your lordship will come back to the RTI reply. Serial number 3. Furnish recruitment rules for the post of assistant marketing inspector, the post in which we were appointed. There is no frame rule for the RR for the post of AMI. RR is under submission for framing. Meaning thereby we are just randomly picked, madam.
What is the stand of the respondents with respect to the promotional aspect?
Well, they have said nothing, madam. They have only said we have accepted without any demur in the year 2004. They have not said anything about the change in the conditions of my service. They have not.
There's a post of agriculture marketing inspector, isn't it?
Yes, this is the post of every.
And above that, what is there?
Above there is marketing inspector.
So that means there's a recruitment rule.
As of now, nothing, madam. Even for the post of AMI, if your lordship is.
How will you fill up the post of marketing inspector then?
My lord, we don't know, my lord. For the post, if your lordship will see, for the post of AMI also, my lord. No RR, my lord. We have just been picked up, my lord.
Is it like that? AMI agriculture assistant marketing inspector, there's no recruitment rules.
Lord, will kindly turn the page on 53, madam. About my lord, planning.
This is statistical and marketing.
Marketing inspector.
So they are both are common. or they are separate, statistical inspector separately, marketing inspector separately. And what is the, how is it to be filled up? This is a part of the writ petition or your counter affidavit?
Page number 60, madam.
This is a part of the writ petition or counter
Part of
affidavit?
it. Part of it. Writ petition.
Writ petition means, not the counter affidavit,
No,
in the writ petition.
page number 60, madam.
%50 promotion from GLW senior
Madam.
and 25%
25% promotion from amongst the UGC. 25% is for direct recruitment, madam. 75% for the marketing inspector, 75% by promotion, madam. Out of this 75%, 50% by VLW, that now it's the AFA senior, and 25% by promotion from among UDC of the department.
you have filed counter affidavit, Mr. Chairman.
Madam.
What have you stated?
Our stand ballot, when ballot in the 2004 ballot, when this petitioner ballot were given appointed in the post of AMI. At that point of time, my lord, it used to be a promotional post, my lord, from the AFS junior, my lord. The promotion of AFS senior and AMI, my lord, used to be equivalent post, my lord. Accordingly, they being the senior, my lord,
Which is equivalent? AMI,
and AFS senior, my lord.
AFA senior.
Senior, my lord. They were in the year 2004, my lord, they were AFS junior, my lord. Now their promotional post, my lord, at that point of time, or AFS senior, my lord. Now this AMI, my lord, were equivalent, having equivalent pay scale with par with this AFS senior, my lord. Accordingly, they are appointed in AMI, my lord. Now subsequently, my lord, this pay scale of AFS senior, my lord, AFS senior has been sent. After 15, my lord, will find that starting from page number
93, madam.
93, madam. Our statement, my lord, page number 78, my lord, or 97, the para 6, 6. Para 6. The respondent back to submit the appointment of petitioner to the post of assistant marketing inspector was as part of seniority list. Post of assistant marketing inspector are equivalent to the post of AFS senior in term of pay and BPS as treated as promotional post.
So you are saying that it is at par with AFA senior.
Yes, well, at that point of time, in the year 2004, my lord. Subsequently, my lord, this pay scale of AFS junior, my lord, and senior has been sent, my lord. But this,
That we have not stated anywhere, apart from saying that much only.
Yes.
6. Subsequently,
that-
this happened, how do
that we
you,
have
from where you saying
stated
that?
page number para 10, madam, page number 79, madam. Page number 79, or 98, madam, 98, madam, para 10. Madam.
You might not come forward means what?
Basically, what they have said is that we should have taken some active part to upgrade our payment. What I can understand.
Set aside your own order.
Madam, yes,
2004.
yes, madam, and for promotion, madam.
But there's no rules for promotion.
It's your lordship would once again come to page 83, madam. Now my brother has said that it was in terms of seniority. And your lordship has seen in the first RTI, madam. This is the second RTI reply, madam, at page 83. Down below, it's serial number 5, madam, page 83. Whether assistant marketing inspector is a promotional post of agricultural field assistant junior, AFA junior. So in the reply, they have said assistant marketing inspector and agricultural field agriculture AFA junior are on the same grade pay. Number 2, as per recruitment rule, there is a promotion of post from AFA junior to AFA senior that we have seen, madam. And 3, recruitment rules of assistant marketing inspector AMI is still under process. Now they cannot say that there was some criteria to appoint us, madam. Now the judgment that has been relied on by Thurston Similar, 2008 judgment by the Thurston Similar, it says there is in cases of delay also, there's an exception where there is a case of continuing wrong. An exception to this exception is creation of third party rights where I'm claiming seniority, etc. In those cases, belated claims cannot be given. That is what has been said in Thurston, if I'm not wrong. Now here is a case, our pleaded case, at paragraph 21 of our writ petition, we have clearly said we don't want any seniority. We just want some pay. Because there are judgments, of course, your lordship are aware. Firstly, the service conditions, madam, regarding the actual promotion and my right to be considered for promotion is a condition of service. Then secondly, that it's a constitutional bench judgment. Now, secondly, my lord, that Palco and all other cases, HL Tehran, where it has been said, my service conditions cannot be changed like that. I should be given some opportunity, ma'am. Even if assuming that, my lord, that the time we accepted, ma'am, where we told that you will never get promoted, my lord, at that point of time, we will not prepare any RR for you for the next 20, 30 years. You will get stuck there. You will have no promotional scope, my lord. Whether that have been conveyed to us, my lord. The department is saying that we accepted without any demur. You just handed over the appointment order, man. I accept that there is delay, certain delay. But That's why we are also not claiming anything that would affect any third party. Because the Honorable Apex Court has also said, fundamental rights cannot be waived as such. Just because I'm not asking for it.
No, but where is the scope of you being promoted as assistant, field assistant, agriculture field assistant senior?
AFAS senior. I'm just basically I'm seeking for
On what basis? How can you be promoted to that post?
my lord. I
Whether you are seeking, with fact that you are not seeking any seniority or whatever is a different thing.
my lord,
But supposing even if you are to be appointed, how will you be appointed as a AFA, promoted as a AFA senior?
my lord, I fulfill all the requisite requirements.
As per what provision you have fulfilled the provision? There's no recruitment.
For AFA senior, there's a rule. Recruitment rules is there. Your lordship has seen. It is at page 75. Village level worker senior, my lord. It's at page 78, my lord. Page 78. VLW senior, my lord. It's now re-designated as AFA senior. This is the promotional post of the AFA junior at page 78.
So what is the criteria?
Criteria is a type copy is at page 81. 100% by promotion. Page 81. 100% by promotion and 100% by promotion from amongst the VLW junior of the department having 5 years regular service in the grade with 2 years training in grams GTC Pasigat. That training order that your lordship has seen.
So this is what AFA
AFA senior.
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 Now, from where do you say that this is equivalent to AFA junior is equivalent to assistant marketing inspector,
That is as per their
RTI?
RTI at page 83. Page 83. Whether I've clearly asked or not, because they're saying it's a promotional post at page 83. Whether AMI is a promotional post of the AFA junior. They said no, agriculture, AMI and AFA junior are on same grade pay. Number 2, as per recruitment rules, there's a promotion to the post of AFA junior to AFA senior. Your lordship has seen the recruitment just now, that is at page 78. 100% by promotion from amongst the VLW have served 5 years and have a training of 2 years at the GTC Pasigat. Recruitment rules of AMI is not there. Now, in their reply only, they have said that AMI and AFA junior are same. They rely on some judgments.
Yes, what are they?
Basically, these judgments are on how wrong has been done to me, and then I will also rely on the delay also. I've not read as such, my lord. In 1975, 3 SCC 76, my lord. It's a constitution bench judgment, my lord. Mohammed Shojat Ali, my lord. I will be relying on para 15, 1-5, my lord. Regarding the conditions of service, my lord. That promotion, my lord. Actual promotion and the right to be considered for promotion is condition of service on that point. And HL Tehran, the 1989, I'll be relying on para 11. 11 HL Tehran. 11, it is on the issue that my existing right, advantage or benefit cannot be taken away.
Where does it say that?
Para 11, my lord.
Mohammed?
HL Tehran. The Mohammed Sujat, my lord, is at
Oh, only 15.
only
Oh,
15.
you're in the next
Only
case.
15.
Yeah.
HL Tehran is 89-1 SCC 764. Here on Para 11, my lord. Down below. As now a well-established municipal law that there can be no deprivation or curtailment of any existing right, advantage, or benefit enjoyed by the government servant without complying with the rules of natural justice by giving the government of servant concern and opportunity.
Opportunity being heard
My lord,
in the year 2004.
my lord, that's why I'm just trying to demonstrate how it is. And then and same issue in the Balco, case of Balco, 2007, my lord. Para 35. Now
This is 35 regarding
it's the same issue as Tehran. HL Tehran has also been referred, my lord, in Balco case. Para 35, my lord. Regarding the natural justice. Then delay, my lord, I will be relying. Here, I'll just read one paragraph that is said, para 22, my lord. This was a case, my lord, of course, this is not service matter, my lord, but it was a case where in the year 1986, my lord, the petitioner saved some persons, my lord. But he was a police constable, my lord. In 1986, my lord, he prevented some dacoity, my lord. And only in the year 2008, my lord, when the petitioner was 2008, he approached the court praying for some relief, that award. Now, but the issue, my lord, that I'm coming on is para 22, my lord. It starts from 20, but specifically read only one paragraph. Para 22. In the present case, neither is there accrual of any parallel right of a third party, nor could grant of relief cause confusion and public inconvenience. There has also been no occasion for the state authorities to claim that they are in any manner handicapped to defend their action. On the contrary, this is a case where the appellant sought to explain the related approach by referring to his repeated unyielding persuasions, which the High Court brushed aside mechanically, without appreciating that the appellant had invoked its jurisdiction for enforcement of his fundamental rights under Articles 14 and 21 of the Constitution. When a litigant approaches a High Court invoking its high prerogative jurisdiction with a petition under Article 226 of the Constitution, alleging that the impugned state action is in breach of his fundamental rights, and claims that the breach be breached by issuing appropriate writ order direction as distinguished from a claim for enforcement of a statutory right, it partakes the character of a duty on the part of such High Court to enforce the right breached as the guardian of the Constitution. Law is well settled that there is no loss of a fundamental right for non-exercise thereof, and also that there cannot be waiver of a fundamental right. Hence, no argument can command the acceptance that the litigant seeking enforcement of his fundamental right should be declined relief in all cases of a belated approach, notwithstanding delay, which might not have been explained to the full satisfaction of a High Court. We hold that in cases where a High Court finds that the facts as they have been presented are not seriously disputed, no further investigation into facts is required to be made. The relief claimed in the petition was otherwise due to the writ petitioner, and the same would have followed as a matter of course and been granted had he approached the High Court without delay. It would be iniquitous and inappropriate to deny relief for no better reason than the relief has been belatedly claimed. Now, others also, if there was no delay, what from my level? I would have succeeded now because my service conditions have been changed arbitrarily. Now reading this in consent with the Tarsem Singh, 2008, which have been relied upon by the learned single judge to dismiss my writ petition. My claim for promotion may be notional also, and some pay. It doesn't affect anybody because my specific claim is that I'm not claiming any senior. I'm not interfering with any third party rights that have already been accrued by some third party. So that's why, my lord, I believe that, my lord, the decision of the learned single judge is liable to.
Scale of AFA at the time and AMI, what is the difference?
At that time, my lord, that
When you were given AMI, whether your salary increased from AFA or BLW?
I have enclosed the present, but I'm not. I'm sorry, I do not have that information.
Because suddenly you pay from AFA, you were marched to AMI.
Well,
Was there any salary benefit at that time?
that instructions, I'm sorry, my lord, I do not have. I have only annexed the present salary that I'm getting.
Your representation was regarding what?
Representations, some
Submitted before that.
yes, representations were for promotions, ma'am.
Mr. Soki, you come to page 45. Scale of pay is 4,100 - 6,000 per month. As AMI.
Page 45, my lord.
Yes.
Page 45, my lord, this is agriculture extension officer. Agriculture extension. Oh, sorry, my lord. So,
No. Okay, these are
I'm sorry, I was looking at other
marketing.
marketing. Well, because for the AMIs, no salary, no RR is there, ma'am, till then.
No. Have you been promoted as marketing inspector?
No, man. For the marketing
Just
inspector,
just read the order on recommendation.
that is a wrong order, ma'am. I think the typographical mistake. I'm still AMI.
Okay. It is your document.
Yes, ma'am. This is how the department passed the order, but still an AMI, ma'am.
Anyway, please read the order. Let's read on recommendation.
On recommendation of DPC services of following assistant marketing inspectors under the Department of Agriculture, Arunachal Pradesh, who were earlier appointed on ad hoc basis, have been regularized with effect from the date of their joining as marketing inspector. Because, my lord, will see, my lord, we were as AMI only, my lord. We were regularized. In fact, it should have been AMI only. This is a typographical mistake.
Okay. Assistant is missing.
Assistant is missed.
Okay.
Regularized as
So let us construe it like that. We are regularized with effect from the date of the joining as assistant marketing inspector in the scale of pay of 4,000 to 6,000 plus allowances. Petitioners or appellants are at serial number 4 and 6.
4 and 6.
6 is appellant number 1.
Yes.
4 is appellant number 2.
Right.
Now, before this, what was your pay as the AFA? 38 AFA. This is November 1988. Pay scale was 975 to 1540.
It was page 88, page 38. It was in the year 1988.
Pay scale of 975 to 1540 per month.
This was in 1988, and this my order as the AMI is of 2004.
But as per the what do you call that RTI reply,
Man,
both posts are similar,
my lord.
equivalent.
equivalent,
At page 65 or 83.
83, my.
Assistant Marketing Inspector, AMI, and Agriculture Field Agriculture.
Page 83.
Agriculture Field Assistant, I think.
Assistant.
AFA Junior are on the same grade pay.
That can be seen at my lord, page number 52, my lord. 52. APA senior. Page number 52, my lord, with by pay scale. Five. At that point, in the year 2000, my lord, pay scale of junior was 3,285, 4,900. APA senior was 4,100, 6,000. Equivalent to AMI, my lord, at page number 45.
Correct. Same scale. They're same scale on 4,000 to 6,000. Correct. Only thing is that you've come after 2004
My lord, that,
and 2024.
that's why, my lord, my great cases, my lord, I'm not claiming any seniority, my lord. At page 29, my lord, my.
Can you separate that? You separate seniority, I don't want. Give me only pay. Can you do that?
Yes, my lord. That's why I'm saying that otherwise.
What about the others
I'm-
who are in line?
My lord, we are.
Otherwise, see, promotional post
My lord.
to AFA senior. AFA senior is the promotional post
From
of AFA junior.
junior.
Now, if you move from AMI to AFA senior, what about those people waiting in line in AFA junior?
Well, if they are waiting as such, my lord, that I cannot comment on.
They will
Because
simply ignore you and close their eyes, and let them go and get
no, my
promotion.
lord, but my lord, person
Will
my lord,
wait.
my lord,
Will they do that?
my lord, the persons who have not yet been appointed, my lord, or promoted, my lord, to AFA senior, my lord, their rights are not affected, my lord.
Why not?
Well, because they are not as of now.
No,
Also
there may be some in the zone of consideration.
Right.
We promoted to AFA senior. And here's the appellants or the petitioner who are AMI inspectors in 2004.
Right.
They're coming in now
Right.
in this zone and getting promoted to AFA senior. On what basis? Promotion is always done on basis of senior. So seniority will have to be drawn.
no, my lord,
If your seniority is at the bottom, you not get promotion. You're retiring when? Next year.
next year, my lord, in the middle
so-
part next year.
So what relief can be given to you?
No, my lord, because my juniors, my lord, otherwise, my lord, in that cadre, my lord, I have already completed, my lord. I'm saying what I'm saying is that order by which I have been just picked up and my service condition has been changed, it is wrong. Now, because of that, my lord, my lord, I should be given the benefit, my lord, of promotion from the date when immediate juniors were promoted.
That
In
you could have said-
the cadre of
See,
VLW.
that you could have said at that relevant time, but not after 20 years.
That's why, my lord, that I am relying on
So
that.
that's why I was a bit surprised when you say that, what are you challenging? You said you're challenging your own order.
Well, that is, of course, it's a peculiar situation is there, my lord. That's why I'm relying on that the Ram author also, my lord, because there it has been said, if the relief, it could have been granted without, if I was not delayed, if my approach was not delayed, it should not be mechanically, this, and especially when I'm not trying to disturb any third party rights. Those persons who are already promoted, they are promoted now. I'm not even trying, challenging their appointment also, because I know there is a delay.
Okay, any other authority?
No, my lord.
That's all.
That's all.
Mr. Prema, anything to say?
I say, my lord, Jasmine is a well-region, my lord. Jasmine is my lord.
Okay. So we'll get the order now. Art is right. Art, Mr. D. Soki, learned counsel for the appellants. And Mr. L. Perme, learned standing counsel, agriculture department for the respondents.
My lord.
Stop. This appeal is directed against the judgment. An order dated 7/4/2025, passed by the learned single judge in WPC number 279 of 2024. by which the writ petition has been dismissed on grounds of delay. So D. Soki, learned counsel for the appellants, submits that the impugned judgment and order cannot be sustained in view of the fact that the continuous wrong has been done on the appellants since they were picked up without their consent from their post as agriculture field assistant junior to assistant marketing inspector in the year 2004. He submits that there is no promotional avenue for AMI. For that, you just put after assistant marketing inspector in a bracket AMI. The learned counsel submits that the petitioners were initially appointed as village level workers in the year 1988, and the said post has been redesignated as agriculture field assistants, bracket AFA, on 19/5/2000. Thereafter, the appellants have been AMI. The year 2004. To be precise, 15/10/2004. So the learned counsel submits that the petitioners have not earned any promotion till date, since there is no promotional avenue as from the post of AMI. He submits that the petitioners are now on the verge of retirement, and therefore they should be considered for further promotion as AFA senior in view of the fact that the post of AFA junior and AMI are the same grade pay. Which can be seen from the information furnished to the petitioner by the Director of Agriculture on his RTI application. So the learned counsel submits that the petitioners, the appellants, are not claiming any seniority, but only their pay benefits in the next promotional post of AFA senior. Stop. The learned counsel submits that delay can not be the ground to refuse the prayer of the appellants, and continuous wrong is being committed. on them. So, in support of his submission, the learned counsel has relied upon the following authorities. Column dash number 1. Mohammed Sujat Ali and others versus Union of India and others. 1975, 3 SEC 76. Number 2. H.L. Trehan and others versus Union of India and others. 1989, 1 SEC 764. Number 3. Balco Captive Power Plant Mazdoor Sangh and another versus National Thermal Power Corporation and others. 2007, 14 SCC 234. And number 4, order dated 4/12/2024 passed by a 3 judges bench of the Supreme Court of India in civil appeal number 13806 of 2024. Singh Yadav versus the state of Uttar Pradesh and others, close bracket. Next para, Mr. L. Perme, Learned Standing Counsel, Agriculture Department, on the other hand, submits that the writ petition filed by the writ appellants has rightly been dismissed by the learned single judge on grounds of delay, in view of the fact that they had been, in view of the fact that the cause of action arose, if any, way back in the year 2004. But the petitioners, but the appellants, as writ petitioners, have approached this court only in the year 2024, after 20 years. Stop. He also submits that the appellants cannot say that, submits that the appellants cannot be given any relief at this stage due to the fact that third party rights will be affected. Consider the fact that they have claimed promotion to the post of AFA senior, which is the promotional post for AFA junior, as per the recruitment rules. The learned standing counsel, by referring to the affidavit opposition filed by the respondents concerned in the writ petition, submits that you would rely upon the same to answer the grounds taken by the writ appellants in this appeal. Stop. He thus submits that since the appeal has no merit, the same should be dismissed. Stop next para. We have heard the submissions made by the learned counsels for the rival parties. We have perused the materials available on record. So the case of the appellants is that they were initially appointed as BLW in the year 1988. And thereafter, in the year 2000, the post was designated as AFA Junior. Subsequently, the applicants were appointed as AMI in the year 2004. So there is no dispute to the fact that there is no promotional posting for AMI since the recruitment rules to that effect has not been framed. So although the post of marketing inspector, as well as what is the other one? Marketing inspector and statistical officer inspector. Have the recruitment rules, but the post of assistant marketing inspector is not in the leader post for promotion to the post of marketing inspector. So the claim of the appellants is that since the post of AMI is equivalent to the post of AFA junior, they should be considered as such and promoted to the post of AFA senior. So it is the further contention of the appellants is that by making such a claim, they have no claim. By making such a claim, they do not claim their seniority in the post of AFA junior, but only pray for financial benefit in the higher pay as AFA senior.
Sorry to interrupt. I'm not claiming seniority in the post of AFA senior, not
Okay. Not claiming seniority in AFA senior, okay? Instead of junior, you put senior. But the thing is that AMI and AFA senior, they're not equivalent posts.
No.
AFA is higher, AFA senior is higher.
higher.
When they give promotion method, at that point of the they equivalent for method. Now pay salary also method I indicate. A senior method and AMI method were equivalent for.
Show me that again.
My lord, see at page number 45, my lord. Their pay scale is 4,000 and
45.
45. 4,500.
Mm.
And page number 52, my lord. Same pay scale is for serious 52, 52, 52. Two, my lord. It serial number 2, my lord. Same pay scale, 4,000 serial.
No. This is AFA senior.
Senior, my lord.
This is where he wants to go now.
No, my lord. When they will give promotion, my lord, at that point of time, my lord, they were AFA junior, my lord. Now their promotion post was AFA senior, my lord. That were equivalent to AMI, my lord. Even in terms of pay scale also, my lord, my pay scale, my lord. They were AFA junior at that point of time. Now they were given promotion to AMI, my lord. AMI, my lord.
So AMI already has the same pay scale as AFA senior.
Senior.
So where is the question of promotion for the promotion? So
Now, my lord, in the year 2016, my lord, this pay scale of AFA senior has been enhanced, my lord. Now they are claiming that. AFA
okay, AFA senior has been enhanced.
enhanced, but they are
Okay.
Now I'm in the grade of a junior.
now after 2016, my lord, the pay scale of AFA junior and this AMI is equal.
But your pay is similar to senior
So junior.
because of the enhancement.
Enhanced, yes, my lord.
If just take your lordship to page 85, my lord. Page 85, my lord. Page 85 and 86, these are the appellants, my lord. Here we are getting 82,356. Resume करवा के
No,
AMI.
it's okay. If it's not in dispute, we'll accept that.
No,
That,
just I will show one more. Another,
That you were at par. AMI was at par with AFA senior. But later on, AFA senior has been given higher scale.
Right.
But AMI remains the same. So you're not seeking promotion. You're seeking only financial accreditation.
basically, in my petition,
But where is the prayer on that count?
it's not there. But my pleading is that I'm, and one more aspect that I have shown my page 91, my lord. These two appellants, they are in Alo, West Siang district, my lord. And at page 91 and 92, my lord. These are from East Siang. My lord. We are in West Siang. These are from East Siang. My lord. This is so and so.
Who are they? In what post?
AMI, my lord.
AMI.
AMI. They are getting the payment of the AFS senior, my lord. 92 to 84. In their affidavit, they have said this is a clerical mistake, but these persons are still getting that salary. And we are getting 83, 82 at that page.
No, that means there are others in the post of AMI who's enjoying higher scale. Well, there are some
Yes.
who are like you, who are getting only the lower scale.
And this
And they're
higher
also-
scale, they are saying it's clerical mistake, but they are still getting that salary. Of course, that deduction is
Where
also.
is enhancement or
They-
enhancement of AFA and AFA senior to the higher scale? Enhancement have you annexed?
No,
No, my lord. But in RK reply, it was in 2016, my lord, we can evaluate. Enhancement since when? 2016. 16. They, from 2004 to 16, my lord, they AFA senior and AMI have same pay scale. They enjoyed it
2016,
up to 2016.
after 2016, they have gone up.
AFA is senior.
But some of them are still paid.
No, my lord, that we have made took a category standard, my lord. If that is here, that is wrong, man. That is not intended.
still getting.
Okay.
Page number 83, my lord, we started. Page number 83, my lord. Page number 83, my lord. In past, my lord, remark column, my lord. Upgradation of grade pay scale of 2004 to 2008 to the post of agriculture AFA senior in the 2016. 2016.
Okay. Please continue. It may be seen that, next paragraph. It may be seen that the pay of AFA senior is equivalent to the pay of assistant marketing inspector. which can be seen from the order dated 15 October 2024, bracket page 45, and order dated 19/5/2000, bracket page 52. So both the posts are in the pay scale of 4,000, rupees 4,000 dash 1,000, rupees 4,000 dash 100 dash 6,000 per month. So it is, however, the case it is, however, submitted at the bar that the pay scale of AFA senior has been enhanced. So according to the appellants, some of their counterparts who are working the East Siang district at Pasighat are getting the enhanced rate given to AFA senior, although they are also working as AMI. Now, it may, however, be seen that the appellants have not made any prayer in this regard in their writ petition. Stop. All that has been prayed for is for quashing the impugned order dated 15/10/2004, by which they have been appointed as AMI in the scale of is 4,000 100 6,000 per month. The appellants have further prayed that they should be promoted to the post of AFA senior. Their immediate juniors were promoted and granted. The immediate juniors were promoted, and also to grant them all consequential benefits to such promotion. So upon this aspect, it may be seen that their appointment to the post of AMI was 15/10/2004. And in the absence of any recruitment rules by which AMI can be promoted to the post of AFA senior from such prayer at this stage is only found to be belated. So we therefore do not find any reason to disagree with the learned single judge insofar as delay claiming such a relief is concerned. So, in respect of the claim of the appellants that their counterparts in other parts of the districts are getting the higher pay as AFA senior. We are of the considered view that liberty be given to the appellants to approach the authorities concerned such grievance, since it is not a specific prayer made in the writ of petition. And in the event such an approach is made by the appellants, the respondent authorities shall look into the matter and pass consequent appropriate orders in that regard. Stop. If there has been a mistake in granting such higher scale to similarly situated persons in the post of assistant marketing inspector, the respondent authorities would convey the same to the petition appellants and take further steps as may be found to be necessary in this regard. Since we have agreed with the finding and decision of the learned single judge as regards delay, the authorities relied upon by the learned counsel for the appellants is found to be not applicable to the present case, the given facts and circumstances. So it may also be mentioned here that case of Ram Avatar Singh Yadav relied upon is a case wherein third party rights was found to be not affected and for which relief was granted. So same is not the case in the present case. Accordingly, the same is also found to be not applicable. The above observation direction, the appeal stands dismissed. Mr. Prokasta is there?
I'm on the line, my lord.
Yes, what do you want?
My lord, today, my lord, the government is supposed to, my lord, produce certain instruction. The pinpoint question was raised by this honorable court is that whether they are in existing post in
Which
Longding,
case?
my lord,
Which case?
item number 28.
We'll come back at 2 o'clock.
My.
Item 44.
The appeal is dismissed and the IA is closed. Interim order passed earlier, stand merged with this order.
Your Lordship,
Yes.
Your Lordship may allow to take this 38 to 39 after vacation. Your Lordship.
Sorry, item?
Item number 38 and 39
After vacation.
after vacation. That may be allowed to take after vacation.
Spread for by Mr. S. Now, Learned Counsel for the petitioner is the matter after the ensuing vacation.
But and I'm sorry that in earlier the PIL 1 to 22, Your Lordship may give the time frame also when to fill up the special deficiencies. The time frame may be given that earlier PIL 1 to 22. I could not mention for the time frame.
They'll do it on priority basis. We had said priority basis. So that should take care of it.
Maybe it's 5-6 months, no issue. That can be mentioned. That would be good. Also. Time frame.
And that get one of in case of such one of the highest level government have take decision on that, it takes time. Time frame difficult, but I personally.
Okay. Okay, we'll see.
Obliged.
May I, Your Lordship?
Yes,
So I like to mention item number 42, Your Lordship.
42.
This matter to be listed after reserve. Your Lordship.
Wait,
This matter, AHR is Nabon's and this is left report, Your Lordship.
why did you leave the board?
It's on. There's no much issue only for directed for vacation verification only that we are not for. And then they are on record, admit that they have not done the verification in that particular plot. Allotment are there in the petition also, and also in their affidavit, but they have could not conduct the verification because of lack of equipment. Only are there expect that this verification be conducted.
Who's appearing for the other side? Government?
Arish Nabam, Your Lordship, AAG.
Oh.
This is left court, Your Lordship.
So there's been expressed on behalf of Mr. Was there before?
AAG Arish Nabam, Your Lordship.
Oh.
RH Nabam.
That's about. Thought he was here.
This was here, Your Lordship. Just let me know.
Difficulty has been expressed on behalf of Mr. Arish Nava, Private Council for on an additional application and appeal for the state. And on a prayer maintenance, we have not objected by the other side. It's the matter. Sweet.
Yes, Your Lordship.
Item number 28.
May I please your lordship, my lord? On the last occasion, my lord, the government was, my lord, advocate was directed to produce and record certain instruction. Instruction, my lord, on the point that whether there is any post of permanent substantive post of, my lord, district treasury officer in, my lord, Longding district. Because I was transferred at Longding from, my lord, Tawang in my existing capacity. And after having joined there, I have come to know that there is no any post. And it was admitted position that court has also taken into consideration that at the time when transfer was made, there was no any existing substantive post. I was given the additional charge as STO, Sub-Treasury Officer. And on the background, my lord, in view of that factual situation, my lord, ultimately court single bench was, my lord, pleased to dismiss the writ petition, saying that though there is no any, my lord, substantive post, but there is no any infirmities. And having agreed, my lord, we have challenged, my lord, filed this present writ appeal. And my lord was pleased to, my lord, on the earlier occasion to direct the government to obtain certain instruction, whether there is any substantive post of DTO. Because they filed their affidavit, they said, my lord, it is under the active consideration of the government. Sanction and creation of the post is under active consideration of the government, meaning thereby that there is no post. Court has also accepted the, my lord, said factual situation. And court has ultimately observed that though no transfer can be made against non-existing post, but since there is no any affirmatives, my lord, infirmities, therefore court is not inclined to, my lord, interfere with the matter.
So let us ask the government counsel, what is the instruction?
If, it's about the lawsuit for creations of additional post, additional sanction post of treasury official. So I have been informed that lawsuit is it's already almost done lawsuit, but it is replaced before the cabinet. Therefore, lawsuit likely to take another 4 months lawsuit. That's the status.
Another 4 months.
4 months.
Then lordship can you grant a stay order, my lord?
No.
Once you are saying your admitted position, there is no post, now they are going to, my lord, create the post and submit to cabinet approval. Meaning thereby that, my lord, there is no post. And therefore it is settled position of law.
Merit law. How the petitioner is prejudiced lawsuit. Question is that lawsuit.
Question is not that. Question is that. Question is that, my lord, question is that whether
he is appointed against the sanction post. There is a treasury official lawsuit.
What is the sanction post?
So this is adjustment among the lawsuit, the total strength of the post only lawsuit.
We should kindly say their
because
affidavit.
he is appointed against the lawsuit sanction post, and his post is attached with all the service benefits lawsuit. Only the concept of the post and the posting place, they are two different concept lawsuit. Now my petitioner is mixing up these two concept lawsuit.
No, where he's posted as he's a treasury officer.
Treasury officer earlier he was in Tawang laws.
Tawang.
Now he has been posted at Longding as a treasury officer only. Law. After
What is the
upgraded the sub treasury office to treasury office.
What is
What is the
sanction
post?
required?
Lordship,
Why did they
since
strengthen
Lordship, we are Lordship creating another Lordship this place of work Lordship. So therefore Lordship additional post has to be created Lordship. That's all Lordship.
Additional
No,
post
this is
such
not,
as?
absolutely not wrong projection of the case.
Treasury officer.
Just a minute, Mr. Prokashta. Don't talk simultaneously. Let me just hear Mr. Tapin first.
Madam.
Lordship, earlier Lordship, Longding, it was having Lordship sub treasury officer. Thereafter it has been upgraded to treasury officer, district treasury officer. Now it has to be manned by the treasury officer. So since it has been upgraded as a treasury office,
From sub treasury office to treasury office.
treasury. Now it has to be manned by the treasury officer. Since it has been upgraded, and we have in state Lordship, we have a particular total strength of. Since it has been upgraded, then we have to create one more post of treasury officer to main Lordship, because now earlier Lordship, suppose say 10,
No, then where is he posted now?
this posted at Longding,
No, he's posted at Longding against what post?
treasury officer.
Treasury
Why
officer.
is
But
it-
you say that treasury officer post is to be created.
Here Lordship, since this another
If it-
thing Lordship.
If it is yet to be created, then how can you
No, no,
post it as a
create-
treasury officer?
No, creation is different thing Lordship.
Okay.
Because for the purpose of justification, only the place of works are Lordship taken into Lordship. Otherwise, how much has to be created? It's up to the government only Lordship.
No, that is another aspect.
No.
Question being raised here is, he is a treasury officer in one place
Lordship.
and he's been posted to another place where there is no post of treasury officer.
No. Treasury office is there Lordship.
That's sub treasury office
No. It has been upgraded by order.
upgraded as a treasury office,
Treasury office.
but the post of treasury officer is not there.
After it has been upgraded, Lord. Suppose say earlier Lord 10 treasury offices, Lord. 10 treasury officers. Now Longding it has been upgraded. Now it becomes 11 Lord. Total strength of the treasury officer is 10 only. Lord. Now one more post has to be created. Lord. The creation of post is not respect of the particular, because one is not appointed against the particular place only. He is appointed in particular cadre, he can be transferred to any places where the treasury office is available. This is the concept of it. Now petitioner he is working as a treasury officer in the Tawang Lordship, and after upgradations of sub treasury office to treasury office Lordship, he has been posted there Lordship. And he is not prejudiced at all Lordship. He is joined salary there Lordship. He has joined Lordship. He is serving as a treasury officer, and he is given the duties of treasury officer only Lordship. Because that office is the district treasury office Lordship. He is performing the duties of treasury officer only Lordship. And he is doing the salary of treasury officer Lordship. How the petitioner is prejudiced. Now, so for creations, because now it become 11, for example, creations of the another one post, this internal Lordship, the business of the government Lordship. Until unless that is created Lordship, adjustment has to be done among these 10 existing sanctioned posts of treasury officer Lordship. They have to be placed here and wherever they are required Lordship. That's the arrangement to be done by the government. And so, for creation is concerned, Lord, that's the internal business of the government, Lordship. And here, Lordship, the petitioner is relying on one judgment, Lordship. That's Jumtum Tato, Lordship. Where, Lordship, the petitioner, Lordship, he was working as a chief engineer, Lordship, in particular department. And he has been posted and transferred and posted as a Lordship, this OSD to particular Lordship. Authority Lordship. So OSD, because it's non-existing post Lordship, therefore it has been held by disorder court Lordship. One cannot be posted to the Lordship post which is not existed Lordship. So relying on that Lordship, this the writ petition was filed. The learned single bench has distinguished these two Lordship situation. Two facts have been nicely.
Okay, so that is regarding OSD. But here is a case wherein the treasury officer has been posted to an office which is a sub-treasury office, but recently upgraded to a treasury office.
It was upgraded long time back, 2020.
Upgraded.
It was notified in 2020.
But the upgraded treasury office does not have the post of treasury officer. is it?
No, it's there.
You may post the treasury officer.
After it has been upgraded, also, who has to man that office? Also?
Now, treasury
Sub-treasury
officer,
officer, he cannot man that office. Also.
treasury officer is in there under what cabinet?
The officer itself is a cadre.
Is it so? You don't have the finance and account service.
Finance and account service.
So there'll be the officers to man the post. That post will be named as treasury officer. But treasury officer by itself may not be the post. It may be manned by the finance and account service personnel. The cadre is finance and accounts officer. I mean, FNAS, accounts officers. They may be posted anywhere where they have the what do you call it? Cadre post. It may be anywhere. It may be in the police, it may be in other departments also, they can go there. But when it comes to treasury, they'll be known as treasury officer. And when they go to some other departments, they may be known as finance officer or something like that. Finance and accounts officer.
That may be correct, Lordship. So here, Lordship,
Where's the posting list?
Lordship,
Order of posting.
My lord, 81, page 81.
serial number 1, Lordship.
Different. Let me appoint the deputy as sub-treasury officer.
Serial number 1, TO is the treasury office.
Serial number 1, page 81.
Page 81A, Lordship. 81 is the 81 is correct, Lordship. 81.
1A.
No, 81 and 81A is same.
81A is type copy.
81A is the type copy. Lordship. From 81 itself, Lordship, it's clear, Lordship. He has been transferred from Treasury Office Tawang to Treasury Office Longding.
Page 81. Annexure 6.
Annexure 8.
8. Right, the annexure 6.
This is order dated 24 July 2020. Annexure 8, page 81, and this is order dated 24 July 2024. So,
Annexure 6 is the original appointment order.
Page 81 is order dated 25th of March 2009.
Yes, sir. 24
Annexure
7.
6.
Annexure 6 is the original appointment order. I was appointed against the substantive post of GTO.
Let us find out what is the order. Where's the order? We cannot locate the order. What is the order dated?
this is 24
Order-
July 2020.
24th July.
2020. The impugn order.
Now, annexure 8. This is page 84. Page 84 is the original copy. 85 is the type copy. What is the name of the appellant?
Petition serial number 1. Serial number 1.
Your book.
Lordship is correct. I think substantive post is finance and accounting. Is he given on the top?
Nature can be anything. Treasury officer, assistant, deputy, whatnot. But the cadre service normally would be the finance and accounts officer.
Yeah, correct, correct.
Serial number 1 is the petitioner.
This is the
This is the transfer order.
this is the it's included in the read.
He will hold additional charge of STO Kanubari.
Kanubari is another
Longling or Longding?
Longding. This is not Longling. It's
Long spelling mistake.
in place of L, it should be E.
So this was challenged in the
Read petition.
writ petition. Where's the writ petition copy? The prayer?
Read petition
Page
is page,
82. Page 82 also.
at page 89, read petition is 89.
And prayer is it is
92. It starts from page 92 also. Yeah.
90.
92.
92.
Page 90.
But here out here it's 97.
I think it,
Why
because of
different pages?
pagination is
My
Not
petition
daily.
is 92.
prayer.
It's 92 in my brother's copy. Mine is 97.
Oh, sorry, my lord, then. Extremely sorry, my lord.
Setting aside the interim transfer order dated 24/7/2024. And what has the single judge held?
My lord, single judge has that, my lord, though there is no any post at the time of transfer, but I didn't find any infirmities. But at the same time, observation was made there, no transfer can be made against a non-existing post. My lord, kindly have a look the findings of the court, my lord. At page 107.
Don't give me the page because it's not telling with yours.
Para 10, my lord.
What do you want to show? What do
I
you
want
want to
to
show?
show that. I want to show
The
that, my
judgment.
lord, court. Yes, judgment.
There are 10.
Judgment paragraph. Tell me the paragraph
Para
number.
10. Para 10.
Para 10. What is the page in your copy?
My page, my lord, my petition 107.
Okay, mine is 112. Read paragraph
Extremely
10. Yes,
sorry.
one.
Part 1, 2, 3, 4, and the fourth line. Although no sanction post of the Treasury officer exists at the time of the transfer of the petitioner, the sub-treasury office having been upgraded to district treasury office, it cannot be said that petitioner was being transferred and posted to a non-existent post. That is the findings. Therefore, my lord, upgradation of my lord sub-treasury office to my lord district treasury office, that doesn't mean that my lord post was upgraded. Office was upgraded, I can understand, my lord, STO to DTO. What is the post? There may not be any difference from my salary, my lord.
Then come to paragraph 16.
Yes,
You're getting the salary of a treasury officer, isn't it?
that's right. That's
Yes.
right. That's right.
Salary and perks, everything.
No
Yes,
service conditions have been affected.
Yes, it is
Duty is
observed that
performing of treasury officer.
my lord, paragraph
Salary is
16.
getting-
My lord, paragraph 16, I'm reading, my lord. It is observed that
Yes.
dismissal of the paragraph 16. It is observed that dismissal of the writ petition rejecting the claim of the petitioner would not be construed that an employee can be transferred and posted to a non-existing post. What has my lords accepted the settled position of law? But although writ petition was dismissed, that doesn't mean that government will have the privilege to make upon my lord transfer against a non-existent post, which leads to
So
conclusion
what-
that
what it means is that
There cannot
you
be
have
any
been
transfer
posted
against
there.
non-existing.
No, you have been posted there because of the attending facts and circumstances. That is, the Treasury Office, Sub-Treasury Office has been upgraded to Treasury Office.
Yes.
So it is for that reason it has not been interfered with. At the same time, it would not mean that one can be posted to a non-existent post.
Yes, madam. Therefore, the course, madam, pinpoint to be
That's
considered
what
by
the
this
court
honorable
says.
court. Madam, pinpoint the issue to be considered by this honorable court is, my lord, whether there is an existing post. And government has filed, my lord, respond number 2, file affidavit. My lord, pointing out that this is the only question to be considered by the court, whether there is any post or not. In their affidavit, kindly, my lord, see their affidavit,
Page 98.
page 90.
Okay. Okay.
Madam, I don't know, madam, whether there is any anomalies in the pagination. Para 5 of the affidavit.
Discussion.
Kanubari is this is sub-treasury office of another district. Kanubari is another place. He has been transferred as a treasury office Longding. Then in addition to that, he will be holding the office of the sub-treasury office, Kanubari.
Sorry. What the appellant is saying is that he has been posted from Treasury Office to Treasury Office. No problem. Treasury Office to Treasury Office. But the thing is that the Treasury Office at Longding
There is
does
no
not have
post.
a sanctioned post of Treasury Officer. Although he is a Treasury Officer in Tawang,
Yes, madam.
but that post is not there. That is why he has come with this grievance. You are saying that no, he is getting the pay of Treasury Officer.
Here was if
And what should be, why there will be any problem? He's a Treasury Officer. He'll be posted there as a Treasury Officer, although the post may have to be sanctioned later on. But then what I told you is that Treasury Officer is for that post, for that office only. The person who is appointed, he's supposed to be in a cadre of service, which is called accounts, finance and account service.
Finance and accounts officer.
They move from
There is
here
a
and
group-
then they have various posts. The gathered posts in various departments, they'll be having gathered posts. Because each big department may have some finance officer in their department. FAO, they call it finance and accounts officer. So when he's posted in the treasury, he's known as treasury officer. When he's posted out somewhere in a department, he may be known as a finance and accounts officer.
Yes,
So now
madam.
the problem is that you say that he's not missing any pay, he's not missing any of his perks. Why should he be aggrieved?
even the duties. Same.
Appellant says that I've been transferred to that office, but that post is not there. Although you give me salary of ATO, but that post is not there. So this is how
Otherwise,
do we
otherwise, my
reconcile
lord,
this?
we also raised a question, my lord. This type of transfer will terminate my right to lien. My lord, fundamental right 15A. I have a right to, my lord, retain the lien on my substantive post.
Exactly.
That
You
aspect
belong
was
to
not
which
even taken
cadre?
into
Mr. Prokashka, you belong to which cadre of the service?
my
Any
cadre is
grade?
Group A gazetted. And
Group A gazetted.
yes. And my lord, STO is Group B gazetted. And there is a difference of pay scale also. My pay scale initial pre-revised pay scale was 8,000 to 13,500. And their pay scale is, my lord, 5,500 to, my lord, 8,000.
Okay,
And
as
it is
on
a
today, as on today in Longding, what are you receiving? The scale of STA or scale of
my lord, to be frank
DO?
enough, my lord, yes, ma'am, to be honest enough, my lord, I have made a query and ultimately, my lord, I got the instruction that he is receiving the, my lord, existing pay scale. Whatever
Existing pay
is
scale.
pay scale of
So,
DTO.
So what prejudice is caused to you?
Question is not that, my lord, whether it is within your privilege to transfer a government employee against a non-existing post. You may be provided me a car, you may be provided me, my lord, quarter, you may be provided me other facilities. But what post I am holding? This is the question. And it is the, my lord, it is the findings of the court itself that at the time of transfer, there was no any sanction post. And they filed their affidavit saying that it is under active consideration. Post is yet to be sanctioned. My lord has rightly pointed out. So whether I am getting salary or not salary, this is immaterial. I have no objection if I do get, my lord, less salary. But my grievance is that I cannot be transferred against a non-existing post. I cannot be transferred other than my substantive post.
Okay, what are you relying upon? The OSD judgment?
My lord,
Do you
two
have
judgments we
any
have
other
relied on.
judgment?
My lord, any other judgment, my lord?
Not OSD, any other judgment?
My lord, today, my lord, I thought, my lord, they are going to take the instruction. And my lord, some decision are there, my lord. Today I am not in position, my lord.
So we post it again some other day then, when you are ready.
Lordship, in that case, I pray, Lordship, the matter is after 3 months. Lordship. I have this morning only I have spoken to the committee. I think in 3 or 4 months.
No, 3 months would be for you to create post and all that, everything. Ultimately, if it's created, it becomes infructuous. But
Yes,
in the meantime, the point of argument raised by the appellant is that can you post me there when before the post is created?
yes,
This question has to be answered.
Answer.
Yeah, the one thing. Just because as I earlier also I have submitted.
Liberty of the release of the law. Try again, try again.
I did giving the as they will not complete.
You cannot go to
You don't want the data given.
Would it mean advertisement post? Not your case.
I don't know.
There was a post sanction. Meaning there is no post.
If the concept of post and the posting placement, it's two different concepts. Because when Lordship one is appointed as a government employee, he is not appointed against any particular placement. For the purpose of creating the Lordship post only, the reference is taken Lordship.
Why?
For how many places Lordship, how many posts are required. For that purpose only, for justification, while creating the post, for just purpose of justification only the areas are taken. How many places are there for which this particular post is required. But when one is appointed Lordship, he is not appointed against any particular place.
So that is there.
He is appointed against the sanctioned post which has been created and sanctioned by the government law.
What is the
Once he is
percentage?
appointed Lordship, he can be transfer to anywhere. Lord.
So that's why,
Until unless Lordship, his service
Sir, here,
condition.
my lord,
They
my,
also Lordship. Now, looking also there Lordship everything. At the
my lord,
post, the place of the work also is upgraded as Treasury office Lordship.
my
Now
lord,
one
it is
needed
totally,
upgraded Lordship. Other than
it is,
Lordship, Treasury officer, no one can Lordship hold that main that particular post. Lordship. Treasury officer has to hold it until unless Lordship additional post is created. Lordship.
my lord, a simple question was, my
And
lord,
then it was 10 places, workplace.
speak on the microphone. I think Mr. Prokasta can't hear you. So
Lordship.
he's
yes,
in
my lord,
journey in between.
my lord, simple question, my
As
lord,
I've taken an
he has made
example, Lordship.
something
Earlier,
in it.
Lordship,
Just a minute, Mr. Prokasta. Just a
My
minute.
earlier, Lordship, 10 posts, 10 workplace were there, Lordship. Now, one more workplace has been created, Lordship, by upgrading, Lordship. Now, sanction post is
Upgrading what? The office.
office, Lordship.
But that upgraded office has to be manned by the officer concerned.
Correct.
Earlier, it was the sub-treasury officer.
Lordship.
Now, it is no longer sub-treasury, it will be the treasury officer.
Treasury officer. So,
Where is the post?
for that, Lordship, government has to create an additional post.
No, just by bringing
Until-
somebody,
No, until unless that post is created,
Mr.
Lordship.
Tapin, just by bringing somebody who is a treasury office somewhere, who is a treasury officer somewhere, bringing him to that place, does it solve the problem?
It's the same treasury office, Lordship.
No,
He has to perform the same duties, everything, Lordship.
maybe,
And
but
this is adjustment among the total sanction is same only, Lordship.
but
And he has been the part of total sanction.
what his lien will be against which post? See, what they're apprehending, which perhaps, I don't know, Mr. Prokasta might want to say that, but I don't know whether he'll say that or not, but I'll say. In the long run, supposing they belong to that service, finance and account service, they may rise up to some level. They may go up to secretary finance also.
My lord,
Okay, because they can go here and there. In other states
Right.
out here, maybe same thing also.
yes, yes,
So a question may arise, while you were posted in Longding, you are appointed and posted there against which post?
exactly, my lord,
Then
exactly,
that competition will come, that person who will question that will steal a march over him.
yes, yes,
Lordship, here, Lordship,
yes,
when every benefits are being
absolutely.
given to the Lordship, the petitioner, Lordship, that question cannot come at all, Lordship.
That doesn't mean that I'm holding the
Had
post.
he been posted in a place, Lordship, where post is, Lordship, suppose say what happened in Jumdum Tatu's case, Lordship. Suppose one account officer has been posted as a Lordship, postmaster, Lordship. For that, Lordship, we can understand, Lordship. You cannot, Lordship, act as a postmaster because this is not mean for, that post is not attached with the Lordship finance, the duties to be given to the finance and account officer. Here it's not the case, Lordship. Everything is given to him, Lordship, in that particular posting place, Lordship.
He's functioning as what?
Treasury officer, Lordship.
His powers.
Everything,
What is,
Lordship. Rather, additional
what,
charge of the Kanuvari has been given to him, Lordship.
That is okay, that's SPO.
Yes, STO, Lordship.
what is the law, my lord? What is law? She is to take into consideration what is the law. Can
And
you have any
Lordship,
privilege? Can you have any domain? Can you have any administrative discretion to transfer a government employee against a non-existent post? And you are saying, my lord, you are allowed to hold the, you are allowed to perform the duties.
in impugn judgment, Lordship, the Honorable, the learned single bench has observed,
You have
Lordship,
to
in
consider.
paragraph 14, that in no way, Lordship, the service conditions of the petition is, Lordship, affected, Lordship. Paragraph 14.
Your lordship has rightly pointed out in tomorrow, my lord, a question will arise. While you are working at Longding,
This
you did
is
not hold any,
no,
did not
no.
hold any sanction post. Therefore, there is a
We are
breach.
not.
There is a termination
We
on
are
the
not
end.
altering the Lordship positions of the petitioner in any manner, Lordship.
But they are saying post is yet to be sanctioned. Government has taken a decision to take a cabinet decision, meaning thereby there is no post till date. Under such circumstances, how can you say I am holding in the post of my lord?
That very
It-
sentence is, Lordship, as I said earlier, Lordship. Now the workplace become 11 in numbers, Lordship. For that, we need another Lordship person, sanction post has to be created, Lordship. That's only our Lordship, the meaning of that we need to, Lordship,
Pending creation, you put somebody there. Is it possible?
lordship, because that has to be made by lordship, treasury officer lordship. And he's challenging the lordship transfer order. Now in Tabang, who has been posted, we don't know lordship. Now even if
One
that's turned
outsider
down,
was,
where he will go?
well, one outsider was appointed. Now he was on deputation. It's the Public Information Department. He was brought on deputation. That is the instruction I have received. He doesn't belong to even the same cadre. He belongs to different department, my lord, Public Information Department. And we have made a
Lordship,
statement in our.
See, we'll do one thing. See, we'll post it some other day for hearing. And although Mr. Tapin would say that give us 4 months, like that, 3-4 months, it may not serve the purpose for the appellant.
I'll let us have the purpose, my lord.
So we have it
Yes.
some before that, before puja.
My lord.
Thursday.
Puja is
Thursday?
almost coming. Today is 16. lordship.
Mr.
My lord, only
Prakash
problem
Sir,
is that, my lord, as per the
come
roster,
down
my lord,
to you come down to Narlagan and argue.
only problem is that, my lord, on the next week, as per the roster, Honorable Justice Kadayate will come, my lord, and it is his judgment, my lord, perhaps the matter will not be listed.
Okay.
That is the problem, my lord.
So that's why it has to go after puja.
My lord,
16 years, 18 years.
And
my
more,
lord,
one
let,
more
let
aspect.
them,
lordship.
my lord, let
To
them
approach
satisfy
the
the court.
Court of law, lordship. It's not lordship. One has to satisfy the solar court how he is prejudiced, lordship, how he is
This is
affected,
not the
lordship.
question.
In the present case, in any manner, the petitioner is not affected, lordship.
If you do wrong and you cannot say, I am not going to be suffer any prejudice. What about your action?
How the petitioner is prejudiced? That has to be placed
It
before
is
the
not a
solar court.
question. Question is whether you can go beyond your authority.
Okay,
You
anyway,
satisfy the court that government has got the power even to go beyond authority. Then
See,
my lord,
since we are not disposing of the matter now,
Lordship.
let us have a date
Lordship, after vacation, any day.
and we'll see what can be done.
after vacation, immediately after vacation, my lord.
27 fixes it.
Yes, when is that?
My lord, I'm just
October,
27.
27. I'm having another case. 27th of October.
you want it on 27?
Yes, Lord.
27. My lord was absolutely correct, my lord. My lord has understood the problem and they have no answer.
I don't know. I was just thinking aloud.
27.
27? Okay.
Yes, Lord.
As agreed to by the parties, let the matter be listed on 27th of October.
My lord, may I just make a prayer, my lord? If your lordship is
Yes.
otherwise, allow me, my lord. My lord, if on 27th of October they could not come with a positive, my lord, steps, my interim prayer may be considered on that day. Make an observation, my lord.
One more thing, see, can we have it on 28th, on Tuesday, division bench?
Tuesday,
27 is
Tuesday.
division
28,
28.
it'll be better. 28,
My lord.
make it 28, okay?
28,
If the
my
matter cannot
lord,
be,
September,
yes, if the
September
matter cannot
20.
be considered for October,
My lord, my lord.
October 28. If the
Then
matter
I
cannot
will
be,
have to stay back, my lord. I will have
yes,
to
you
stay
stay
back
back,
for one more day. Because
definitely.
I
After
have to
coming
come on 26.
here, you have to stay 3-4 days.
Yes, my lord. 26, I will have to come 26, then 27, then 28.
Yes.
Obliged, your lord.
It is also provided herein that if the matter cannot be taken up for final consideration on that date, the liberties, the petitioner, the appellant would be at liberty to press the
My lord,
interim prayer.
my lord. I'm grateful, my lord.
Item number 30.
Yes, so Modi.
While so far actions of pleading in the present case is concerned, I have received the affidavit in opposition filed by the respondent number 3, 4, and 6, ma'am.
You want to file rejoinder?
Yes, ma'am. And
How much time?
rejoinder is on, madam. I'm ready to file against the rejoinder, madam. And the respondent number 2 and 5 is my.
You want to file rejoinder or you are going to file against rejoinder?
No, my lord. I am going to file rejoinder
Okay.
against the affidavit in opposition
Okay.
filed by the
How much time?
3, 4, and 6. My lord, 2 weeks.
2 weeks. Any objection? As prayed for by Mr. C. Modi, 2 weeks time is granted for filing rejoinder affidavit against the affidavit in opposition filed by respondent numbers 3, 4, and 6. This is the matter again after the ensuing puja petition.
Item number 31.
May I, Lordship?
Yes.
Your Lordship, here respondent number 4 have filed affidavit in opposition and most of the respondent have filed. And for private respondent, we have served, but it's still in office mode, it's showing unserved, so we may be permitted to serve again.
You may be permitted to serve.
Again, to respond number 5, 6, and 7.
By Dusty?
Yeah.
Oh,
AD, it's AD.
by the registered post. Okay. Now, respondent number 4 has filed counter. Okay.
I'm appearing for one, respondent number 1. So my name may be reflected in an extra copy, Visa.
Extra copy. You have not received.
Not received.
One is what? RWD.
Yes, Secretary.
Your good name, please.
Yes.
S.
So,
Somu. Ms. S. Somu, learned counsel, appears for the petitioner and submits that since notice has not been affected to respondent numbers 5, 6, and 7, she may be allowed to take fresh steps upon them by registered post. Prayers allowed. Stop. Let steps be taken for service of notice upon respondent numbers 5, 6, and 7 by registered post with ADD within 3 days. Mr. Jitara, learned
Standing
standing counsel RWD appears for respondent number 1 and submits that he has not received an extra copy of the writ petition. Stop. He also prays that he may be given how much time?
After vacation, 4 weeks.
4 weeks time to copy instructions and to file counter affidavit. So, praise allowed. Mr. Jitara be furnished with a copy of the extra copy of the writ petition by tomorrow. Miss P. Pangu, learned government advocate, appears for respondent number 4. 2, 3, and 4. What about 2 and 3? They'll be filing and submits that she may be given 4 weeks time to file affidavit of respondent numbers 2 and 3. So as for respondent number 4, counter has been filed. Be of above, list the matter after 4 weeks on a date to be fixed by registry.
Item number 32.
Lordship, in my last order, I was directed to parties when for just this Lordship. Receipt of the Lordship's news for the council's technical.
What is the case about?
My case is no, sir.
the Tirbin Township area, then measuring 490 acres, was donated by some 5 individuals. But they are not claiming that, but Lordship, for establishment of the township area. Now, Lordship, there is a rampant land encroachment in the entire township area. And when the common public, they approach the authority regarding the eviction of all those encroachers, they are not taking any action upon the encroacher law. Lordship, at present, there are only 3 encroachers on the list who has dismantled the government quarters and constructed their permanent structure. Since 2020, the public, general public of township area, they are approaching the authorities for taking action against them. But they are also not taking any action, only issuing show cause notice upon show cause notice, but no eviction drive, anything, nothing has been done, Lordship. And Lordship, the petitioners and the students' organization, they filed an RTA application before the authority concerned, seeking the list of encroachers. And the LOT, they provided only 17 numbers. Means, Lordship, only 17 members, they are having the land possession certificate. But the rest of the illegal encroachers, they are there, but no any action has been initiated by authority. Accordingly, Lordship, I have made a specific prayer in my application PIL, asking for a joint verification. And accordingly, on last occasion, Lordship, this Honorable Court has directed the respondent number 3 and 4 to 4, 5, and 6 to verify identification of the other encroachers. But now, Lordship, they are providing only these 2 respondents and one person. That is Mukar Gamne. These 3 are in the official list who actually encroached. But the rest, Lordship, they have not done anything. So, Lordship, my respectful prayer would be, Lordship, for a direction for spot verification of the encroachers in presence of the petitioner. It would be better, Lordship.
What is the name of the place?
Place Tirbin Township, Lordship.
Tirbin Township. This has been donated by
5 individuals, Lordship.
For establishment of
Township.
township.
Yeah.
And is the land demarcated? The donation.
Yes. Then
How size? How big? Which
yes,
area?
blueprint map was also prepared. I have enclosed the
But according to you, it has been encroached by private individuals.
Yes, Lordship. Now, Lordship,
And authorities are not doing anything.
not doing anything. Lordship, now the government has sanctioned for construction of school building, medical, but there is no place left for construction of all this public.
Who are the petitioners?
Petitioners, Lordship, the credential of petitioner has been mentioned in para 1, 2, 3, 4, and 5.
They are also from Tirbin.
Yes, he is also from.
How many petitioners?
Only one, Lord.
Oh, one.
Yes, Lord. So now, Lordship, now the respondent, they are submitting.
They have filed their affidavit, isn't it?
Yes, they have filed. In their affidavit,
What do they say?
in para 16, may I take you to the para 16 of their affidavit?
Yes. What do they say?
May I read the para 16 of? May I read those?
Yes.
That with regards to the statement made in first 6 lines of para 16 of the FIL petition, the answering respondent offer no comments, being the matter of fact and record. But with regards to the statement made in rest lines, the deponent begs to state that there are some encroachment of government land in Tirbin Township area. And to find out exact number of such encroachment, the local administration state officer needs reasonable time for the necessary survey of the area and identification of such encroachment and to start eviction drive as per law against such illegal encroachers. From this abatement, Lordship, now they are also admitting that some encroachers are there. But for that, they need some more time, reasonable time for verification. But in terms of this para only, this Honorable Court on last occasion directed them to furnish the list. But they are providing this list of 2 respondent, Lordship. And one more, I have made a mention.
Where is the list?
Lordship.
Take more instruction.
No, you said three persons have been invited,
Yes, this
identified. Where are they? That's the list. How many names? 3 names only.
These 3,
This is on the basis of what?
two of them are the private respondent, Lordship.
Already here.
Yes, already here.
And one is also, I have made a mention his name in RTI reply also. That is one. Dr. Mukar Gamlin, 80. He has also encroached the government quarters of Education Department located within the boundary of Government Higher Secondary School. Therefore, Lordship, may humbly pray that Lordship. Lordship, here the respondent number 4 and 5, it is the Deputy Commissioner and the LARSO. They are residing in other district at Lefarada, but Irbin is located somewhere, so they are rarely visiting in that area. So for fair verification and survey, may I please pray that Lordship, direction may be issued to respondent authorities to carry out the survey in presence of petitioner along with the local place authorities, Gaopuras, so that they can identify the encroacher. That will be better. Otherwise, Lordship, it seems they are submitting the same name whom I made as a respondent.
So what are the documents that you have? Your writ petition.
Regarding all those documents, Lordship, I have for the RTI application. RTI application was submitted on 4/3/2020, page 46, Lordship. In fact, Lordship, the blueprint map regarding Lordship, page 42 is the final notification regarding the township area, Lordship, page 42. Final notification was issued in the year 2003, Lordship, whereby the entire this area was notified as a government land for establishment of the township. Then, Lordship, next is the blueprint map of Irbin Township, page 44, Lordship. I enclose the coloring paper also. That is in color. Page 44.
See, the donation was done sometime in 1979.
Yes,
What would be the situation now? Will there be any land left?
Lordship.
Oh.
And then, Lordship, the next is the page 45. These are the only,
Area is 490 acres,
yes, Lordship.
and 3 names have been taken,
Yes, Lordship.
out of which 2 of them is already in the respondent here.
Yes, Lordship.
Now, this agreement was signed between whom?
Lordship.
Who has donated the land?
Was donated by Lordship
And who has taken over? Who has accepted the donation? Do you have the agreement?
yes, Lordship.
Where is it?
Page 38.
it is not that too visible. Page 35 is the.
Who are the signatories?
Signatories, Lordship, are the all those landowners, including the place senior members. Was donated in the year 1979.
No, that we have noticed. So, what are the signatories? Who are these people?
These are the above five members.
Landowners.
Yes, 5 members are the landowners, and rest down below 1 to 10 are the witnesses.
And who else has signed it?
Lordship.
Who else has signed it?
Signed, Lordship.
Anyone from the government?
Yes, definitely, Lordship.
So-
but I don't have the document, but
No,
there
it's not
might be
here.
a proposal from the department, government for establishment. They are asking for some land from the pledges for establishment of the township. Lordship. One document. I have, in fact, I have filed entire documents to ask.
Irvin is in which district?
Lordship.
Irvin.
Irvin. West End.
West Siang district.
Now Lefara the laws. That has been bifurcated from West Siang to Lefara.
What's the western side of West Siang?
Yes.
What's which side?
Here, Pasar.
Pasar.
Yes.
That means it's south. Southwestern. Is it? West Siang is that side, Alau.
Yes.
East Siang will be Pasighat. And Pasar is there on the southern side of,
Southern side.
and this Tirbin would, Leparada would be on the western side. Southwestern side. See, one thing is that the deed is here, but it's not conclusive. Some 5 donors are there, some witnesses are there. Then who has accepted it and who's going to construct that, who's going to make the township? And what is the requirement for bringing the same to the township? Who will do that? People will have to reside there.
Yes, people, yes, Lordship, but this,
Those encroachers that you say, encroachers you call them.
Yeah.
But they have to reside there to have a township.
yes, Lordship, but
It is not that because they have donated, government will bring in this, that, and all these establishments, and no private party should be encroached that land. If you say township, what do you mean by township?
township includes the loss of course, the settlement of the public only.
Public will come. So these public, can you call them encroachers?
Lordship, but they have to obtain the allotment or the proper channel. Lordship. There are the certain restricted area where the government cannot some locations, some areas that are
I
earmarked,
don't know. What do they say?
earmarked for the establishment and
They have already filed counter affidavit. Encroachment in government land. So the very word government land, what I was trying to find out is that deed, this much acres, has it been given to the government for development, for
yes,
township?
yes, Lordship.
So the signatory government is not there. It's all witness and the
Yeah.
landowners.
Yes, Lordship.
5 landowners and 10 witnesses.
Thereafter, Lordship, may I take to page 41, Lordship. On the basis of course, some documents are missing, but in terms of their donation, Lordship, now the Director of Land Management, Government of Arunachal Pradesh, issued a notification. Page 41 is the notification.
Yes, what does it say?
And it is specified here with an agreement deed of land donation for establishment of Tribune Circle headquarters as sought for by your above letter under reference. Kindly acknowledge receipt and confirm action.
So
Here
this
after-
this is only a forwarding of the agreement
Yes, Lordship.
by the DC.
Yes, Lordship. Then next page 42, Lordship. Final notification was
How is it going to be utilized? That has not been mentioned.
not been mentioned, but Lordship,
You cannot have township without people. The people will have to reside there.
yes, Lordship, but through the proper channel, Lordship. They have to apply for the within that notified area, Lordship.
There is a government notification also in the year 2012, whereby the government of Arunachal Pradesh has directed the land department to regularize all those occupants laws. But in my case, Lordship, many of them even not applied for any land allotment application. That has to be considered by authority concerned, Lordship. They, as of now, Lordship, in terms of RTI reply, they have allotted only 17 numbers, Lordship. Means they are legally residing there. I am not objecting, petitioner is not objecting the allottees, valid allottees, who obtain the land allotment from property land. But there are the numbers of individuals, Lordship, who encroach the government notified area, Lordship. Now the problem is, Lordship, even the public, they want school infrastructures, medical, but there is no place left. At least that some place has to be earmarked and identified by the government. That is not done.
So where are the documents
Lordship.
by those authorities looking for land but no land?
They are, the Lordship, in fact, they are not doing anything, Lordship. Even
In other words, can we go for witch hunting? And who is there who has not done like that? There has to be some basis. So far you have shown me that this much of acres have been donated.
Yes.
For the township.
Yes.
Okay, and 17 people have applied so far.
Yes.
And such a big land, plot of land, only 17 people cannot be residing there.
Yes.
There are more people residing there, but they have resided there unauthorizedly.
Yes.
But the difficulty which you have expressed, that the purpose for which it has been donated has not been achieved. And these are the authorities who have complained. At least give us some handle.
We have submitted
Otherwise,
various
calling for like large scale verification and asking everybody to be there, especially the petitioner and all on the documents. Whether that would be
we have submitted various
the
representations.
necessity as of now. We'll ask Ms. Ete to get some more instructions.
Lordship,
And if that is not convincing enough, we may consider your submission for verification. What do you say, Mr. Ete? Please write down. In terms of the last court's order, Ms. G. Ete, Lanet, additional senior government advocate, has received instructions, which is to the effect that 3 persons have been found to have encroached on the land in Tirbin, which was donated for establishment of Tirbin Township. Stop, Mr. K. Lolen Lanet, counsel for the petitioner, submits that, in fact, out of the 3 persons said to be encroachers, as per the instructions of the learned state council, 2 of them are already private respondents in the same standard petition. So therefore, court may direct the respondent authorities to have a verification in the presence of the village authorities, including the writ petitioner. Of this submission, Ms. G. Ete Lanet, that she may be given some more time to get instructions in the matter. Your papa, is the matter again. After the incident application. You have to give some more effort. Otherwise, we might have to consider the prayer of Mr. Lolet.
Item number 33.
Yeah, this matter, my lord, I haven't furnished the copy last night only, my lord. Going through, my lord, it appears that it's challenging the judgment of 2015, my lord, this jail appeal, my lord. So there, my lord, the coronation application and any other thing, my lord, is required to be taken up, my lord.
Where's the judgment?
judgment is at my lord, see page. Pagination is also not.
302.
The only that annex document, my lord.
302 or 304?
302.
Conviction is under 302. Or what?
Conviction is under 302, man. Last page, judgment 13, my lord, see.
Which paragraph?
Para 23, my lord. Section that provides for commercial show and like
Under 302.
22 is convicted, my lord. Accordingly, evidence have a convicted under 302 of IPC. 22, madam. Last.
This appeal is from jail?
Yes, jail. Yeah.
Yes, it's appeal from jail. You are the PP? Yes, I think the PP.
And my
You are
lord,
the?
my lord, it
Amicus.
seems that yes, I've been appointed.
Amicus?
My question,
For the appellant.
my lord.
And judgment was rendered when?
Rendered on 1st April 2015, my lord. The copy of this appeal matter I've been furnished last night only, my lord. That's right.
But what do you say? See, the appeal is from jail. Yes. Person was convicted under 302, then sent to jail. And after many years, he's been able to file an appeal from jail. Yes, to the superintendent of jail. 10 years. So, 10 years. So, should we go into the issue of delay at this stage? Can we not just admit the appeal and hear it on merits? Since matter is from jail. That's why. Since it's from jail, so we consider that we should not need to require. Maybe considering that could be the ground for delay, and we condone it, and list the matter for admission we call the ARCR, admit the appeal.
Maybe.
Yes. Paper book maybe. Because ultimately, after 2-3 months, delay will be condoned.
Exactly.
Yes. Again, same.
Exactly.
Better admit now only. Okay, please write. This is an appeal from jail filed by the appellant for being convicted under section 302 IPC and sentenced. Where's the sentence?
Life, madam. Madam, 32, madam.
Sentenced to undergo rigorous imprisonment for life. There's no fine, is it?
Madam. No fine.
The judgment and order has been passed on 1/4/2015 in sessions case number 123 bracket CLG/2011 by the Court of District and Session Judge, East Sessions Division, Tezu. Since the appeal is from jail, the same explains as to why there has been delay filing the instant appeal. So therefore, the appeal being a jail appeal, we deem it proper to condone the delay and admit the appeal. Registry to requisition the TCR. Mr. T. Tagum, learned legal aid counsel appears for the amicus or legal aid?
Amicus, man.
Learned amicus appears for the appellant, while Mr.
G. Tado, medicinal public.
G. Tado, yes, learned additional public prosecutor appears for the state. Registry to list the matter again after the TCR is received in the orders column. When it comes TCR, we direct for the preparation of the paper.
After receipt of TCR.
Item number 34.
This is the same matter, madam. Jail appeal. So there is also delay, my lord. The date of judgment was pronounced on.
This is an appeal against the conviction of conviction under
302.
Hmm?
302.
where's the judgment?
No, yesterday only I received at 6 o'clock, my lord. So my prayer is that let the same order be passed, my lord.
He received copy at 6 o'clock.
Yes, ma'am.
Matter is taken up at 3:15, 3:20 now. He had enough time to go through it. This is what conviction.
841.
My lord, order is, my lord, 8 page 41, ma'am.
So number 1, then number 2 also is there. Then are held guilty of this offense and convicted them. Then this is the conviction. And where's the sentence? Okay.
That's my 4-1, ma'am.
I know.
10,000. This is a jail appeal, isn't it?
Yes, ma'am.
You want legal aid counsel or amicus?
Amicus curiae.
Amicus. Please write down. This is an appeal filed by the appellant from jail
Under section 374.
on the conviction under section 302/394/120 capital B 2022/34 IPC by judgment dated 22/12/2023 passed by the Court of District and Sessions Judge Pasighat in Pasighat Sessions Case number 28 of 2014. And also against the order of sentence. Is it the same date?
Yes, same day.
Passed on the same date, convicting the appellant or appellants.
Prepare this appeal.
Convicting the appellant, sentencing the appellant to undergo life imprisonment.
Fine of 10,000.
Fine of rupees 10,000. Three two have been convicted.
They all are convicted, but they still appeal is for one person only. There are three accused persons, Lordship. One,
No, you come to page 40. It shows only two persons. Sonu
But-
Goyari,
yes, Lordship, but
Then
this jail appeal
Mandela.
is for one person only.
No, that I understand.
Yes, Lordship.
You said three persons, but I find two persons only.
Oh, yes, Lordship, I am so
Samuel Goyari.
Yes, 2%.
Samuel Goyari is what?
Sonu Goyari.
He is acquitted.
No, Lordship, no, both are convicted, Lordship. In the page 41, it is clear.
No, there are three. Both means two. There are three people in the case.
Yes, Lordship.
Sonu Goyari, Mandela, and then one is Samuel.
But only two were convicted, Lordship.
That's what I'm saying.
Yes, Lordship.
One has been perhaps acquitted.
Yes, Lordship, because lack of some evidence, Lordship.
Samuel Goyari. Some is
In the page 44, Lordship. Lordship, page 44, Lordship, it is reflected that this Samuel Goyari is absconding, Lordship. Page 44. I kindly go to it.
since he's absconding, so he has not been sentenced. Isn't it? Warrant has been issued. That's full stop. Please write. Be it stated herein that there were 3 accused persons in the case, and out of which one has absconded, and therefore the appellant and
Can petition on
one Sunu Boyari were both convicted by the learned trial court and sentenced accordingly. Stop. The instant appeal has been filed by Sri Mendela Elias Kejang
Yang Musahari.
Mushahari. Stop. Although there is delay in filing the instant appeal, but since the appeal is from jail, the same explains the delay, and therefore we deem it proper to condone the delay in filing the appeal. Stop. Let the appeal be admitted. Registry to call for the TCR.
notice may be issued also. Because generally, whether they will participate or not, but notice,
Who?
notice to be issued to the
To whom?
to other party notice to complainant.
Complainant not required. Is it required?
Notice generally is required to serve notice.
No, in the case of POXO cases, the notice goes, but in case of 304, 302,
All cases notice should be required to be sent. Whether if they are not participating, then this is different notice. But notice should be served notice.
issue notice returnable by 3 weeks.
Answer may be called for and the backup.
T. Son, learned counsel, appears as the. You're shown as legal aid counsel.
In the course, this is amicus going.
Direction was legal aid to appoint a legal aid counsel. Miss
Okay.
okay.
Yes, Lordship.
Appears for the state. Registry to issue notice to the complainant by registered post daily within 3 working days. Did I say call for the TCR?
Yes.
List the matter on the SIP of the TCR. The matter again. On the SIP of the TCR.
Correct.
Item number 35.
I would require some more time to file our agreement.
How much time?
3 weeks time, ma'am.
Who's the petitioner in person?
He appears through VC. He's from Meghalaya.
What is the matter?
Madam, it's regarding granting of ST status to the Yogin tribe. It's a tribe in Arunachal Pradesh.
Yobin.
Yogin tribe.
They're not indigenous.
They are indigenous.
Then?
In fact,
all, even the state government, they have recommended for issuing of that ST certificate. And it was examined by the Ministry of Social Justice and Tribal Affairs. There was a ST commission. They recommended that they can be given the ST status. But and thereafter, even this deputy commissioner, they have issued the ST certificates to them. However, their ST certificates are still not recognized by other institutes. That's why they filed PL. They are filing a PIL. They have filed this PIL for a declaration. But there is no amendment in the Constitution. In fact, the constitutional order 1950, their Yogin tribe has not been. That is some difficulty there because of which they are facing this problem. So will file our affidavit. There is a judgment of the Honorable Apex Court saying that all tribes, caste or scheduled caste or scheduled tribe, it has to be specifically mentioned in the constitutional order. For how much time? 3 weeks time. No, yes, for the petitioner. The matter is called Mr. N. Going for the state. Was she the one? No. We can't hear you. Sound?
Item number 36.
No. Then the application, break for the granted for the 3 week pending. Well, you're filing MP? Right. So are you filing any affidavit? That one in the video will not be filed. The matter again after the obligation.
Item number 36.
My lords,
Yes.
I'm entering appearance on behalf of the respondents. Your Lordship, my request is that we are in the process of filing an SLP. My only request is if your Lordship could have it after 1 month, 4 weeks.
No, you appear for which respondent?
Your Lordship, all the respondents.
What is your good name?
My lords, it's Miss Seema Dolo.
Seema
Dolo,
Dore.
D-O-L-O.
Seema Dolo.
Yes, my lords.
Okay. Miss Seema Dolo, Learned Counsel, appears for all the respondents. And accordingly, notice is accepted to be complete upon the respondents. So the Learned Counsel submits that she may be given how much time?
My lords may grant me 1 month's time, 4 weeks' time.
A month's time, 4 weeks' time to file her response of that to the contempt petition. Praise granted.
I'm obliged.
That's the matter again after a month. Mr.
M. Dojimal.
M.
Dojimal.
Doji. Learned Counsel is here for you. Doji, yes.
All right.
Item number 37.
Hi, Lordship. I'm appearing on behalf of Legal Aid Counsel, Uttam Bori, Lordship. He has instructed me to inform this honorable court that he has received the petition copy this morning only. This is also a jail appeal, Lordship.
Where's the judgment?
I have received only the
Judgment.
judgment dated is on 27 to 24, Lordship.
Page 27.
Lordship, I have only the judgment copy, Lordship.
The legal aid, you're for the legal aid council.
No, I'm not for the legal, I'm appealing on behalf of Uttam Bori, Your Lordship.
Huh?
Uttam Bori, he is the legal aid counsel.
That's what I said you're on behalf. What is your good name?
Tirimi,
Sorry?
Tirimi,
Rimi.
yes, Your Lordship.
Please write. This is a jail appeal filed by the appellant. No, cancel that, please rephrase it. This is an appeal from jail filed by the appellant against the judgment dated 27/2/2024 passed by the Court of Special Judge bracket POCSO Act close bracket Khonsa Sessions Division Dirab District in Khonsa /SC bracket POCSO case number 5 of 2022. Affecting the appellant under section 376 bracket 3 IPC and also under section 6 of the POCSO Act. So on his conviction, the appellant has been sentenced to rigorous imprisonment for a period of 25 years, fine of rupees 15,000. The POCSO Act. Default clause. Next para, it is noticed that the matter was listed on 28/8/2025. It was wrongly recorded that conviction is under the Arms Act. And under the 11 provisions of the IPC. So therefore, the same is clarified today. The conviction is not under the Arms Act or the IPC, but under, okay, IPC, I think we have to make it mention. Please read that sentence. Arms Act and IPCSA. And other provisions that instead of that you write under the Arms Act and under section 341/364 bracket capital A IPC. Then please read. not under the Arms Act, IPC cancelled. But one under the POCSO Act, one under Section 6 of the POCSO Act, and Section 376 bracket 3 IPC. Next para. Since no, next para. There is some delay in filing the instant appeal, but the same can be readily explained from the fact that the appeal has been filed from jail. So we therefore deem it proper to condone the delay and admit the appeal. Stop registry to call for the TCR. Stop issue notice, returnable by 3 weeks. Miss T. Rimi, learned counsel, appears on behalf of the Tambori, the appointed legal aid counsel. What about state? No one. For the PP. It's for the state, although Mr. T. Ete, learned additional PP, appeared on the last court date. Registry to issue notice to the informant through Mr. T. Ete, learned additional PP, who shall cause service of notice upon the informant through the officer in charge of the police station concerned. Stop. The officer in charge of the police station shall report back about the delivery of the notice through the additional PP. This is the matter again after 3 weeks.
Next.
I wish to mention the WPC number 442 of 25, which was listed yesterday as item number 6. However, it could not be due to certain clerical errors in the elections, matter could not be taken up. I respectfully request that the petitioner may be permitted to note the petitions, the liberty to file a price.
Was listed yesterday.
Yes,
We have to list it first. You have a mention memo.
yes.
Let it be listed tomorrow. Tomorrow, we'll pass it over tomorrow. Unless it is listed, you don't pass it. Yes.
May I please, Lordship, I have given a mention memo regarding the one unnecessary matter, Lordship. It was right for the listing of this matter tomorrow, Lordship. That is on 17th. See, as per the last order, it was listed as per the last order, Lordship. 2 weeks time was given, Lordship. But it's been like four weeks, Lordship. So
Listed for what?
yes,
You're praying for listing for what?
yes,
For
praying
admission,
for this listing of this matter.
for what? Admission orders or
Orders, Lordship, tomorrow.
orders?
Yes, Lordship. Conducting council is coming from all the way from Guwahati. Lordship. Tomorrow,
What?
matter
No.
can be taken up.
What is the urgency?
Lordship,
When was it last listed?
last it was listed on 13, no, sir. 13/8/2000.
38.
Yes. And as per the order, 2 weeks time was given.
For what?
For Lordship, file an affidavit.
It has not been filed? Has it been filed?
Yes, Lordship.
Yes.
Lordship, I beg to mention one unlisted matter for listing tomorrow.
What is the matter?
Lordship, matter is already pending for this court. So urgency is for this court.
What is the subject?
Subject is tender matter. Lordship.
Huh?
Tender matter.
Tender matter.
Yes, to consider the petitioner in a financial.
Tomorrow.
Yes, Lordship.
Okay. Okay.
Item number 1.
May I Lord?
Yes.
Lordship, I'm seeking for adjournment on behalf of Mr. Titofu. Leading counsel, due to health issue, leading counsel is not present today, so Lordship, matter may be listed after Puja vacation.
This has been served or not? That is for you to check out, Mr. Counsel, for the petitioner. Should have checked. Each non-control, number 2 steps. What does it mean? You have not taken steps and you're praying for time. Then you're enjoying the interim order also. You take steps. What are you looking at? Please write down office note dated 15/9/2025 indicates that the petitioner has not taken steps for service of notice upon the respondent number 6. As prayed for by Mr. Your good name?
T. Takyang, Lordship.
T.
Takyang.
Takyang, Senate Counsel for the petitioner. 3 days time is granted. Take steps for service of notice upon the respondent number 6. In terms of the order dated 28/8/2025. Stop. This is the matter again. When?
Lordship, after Puja vacation.
After the purification. On 23rd of October. 2025.
Macho.
Item number 2.
May I please? This is the madam, tabulation form, madam, list of dates and index, madam, along with the madam. Original document. Madam, may I take your lordship? The affidavit filed by the IDBP, madam, wherein it has been clearly mentioned. He said, madam, the petitioner has said, madam, he absent at the duty time, and arrived 30 minutes late, which is factually, madam, incorrect as per the statement, madam, the affidavit filed by the IDBP. On several occasions, he was found, madam, intoxicated position. Madam, if lordship perused the affidavit filed by the Union of madam, the ITBP, more particularly at paragraph, madam, paragraph B, page number 47, madam.
What is this?
Madam, just may I read, madam.
No, no, what is this document?
This document,
First, you tell me, what is this document?
madam, which one?
You're pointing out some particular page, what is that?
Page number 47, madam, of my affidavit filed by the ITBP, madam. Page number 47, affidavit filed by the ITBP by one Bharat Singh, the then commandant.
47.
Page number 47.
There is no page 47 by Bharat Singh. The last page is page 27. Give him this. Point out some difficulty in the pagination.
Yes, madam, every time, madam, we are trying to, madam, maintain the, madam, the designation. But there's a notification, madam, issued by the principal, madam, wherein, madam, the giving proper definition of madam, page number 3. Maybe, madam, this affidavit before notification, affidavit is filed by the ITBP before notification. Page number, internet page number 3, madam. Brief fact of the case.
Yes,
I'm reading, madam, page B, madam.
yes,
The petitioner number so and so, Omkarnath Pandey, reported on the permanent transfer to 10 BN ITBP on so and so dated from SSP BN. The petitioner was details with internet security herein after referred to as the ISQT. The company deployed at the Itanagar, the Arunachal Pradesh, during the month of September 2016. The petitioner was detailed for night duty on the 14th September 2016 at police station Darjuli, Itanagar, Arunachal Pradesh. On 14th September 2016 at 1800 hours, means 100 hours, when the petitioner was ready to move for the duty at police station Darjuli, Itanagar, the above petitioner was found absent from 31st DNITBP Ken, UPI Itanagar, without any informations of the prior permissions of the competent authority, where the personnel of IAS duty company were stationed. On searching, the petitioner was found near 31st DN campus area with civil laborers in a state of intoxication. On the same date, at around time is very important, madam, 2200 hours, madam, the petitioner was sent back to the 10 p.m. ITBP came in on 15 September 2026 by the company commandant as IAS duty company, madam.
so he was sent back from where to where?
Madam,
He was sent back from which place to which place?
madam, he was temporarily attached with the 31st BN ITBP at UPI, madam. And thereafter, madam, he is basically from the madam, that controlling of the officer is located at Kimin, madam.
So he was sent back to Kimin?
Yes.
Next day?
Next day, madam. So therefore, on the madam, in my note sheet, madam, on 14, this was intimated, flag 1, madam.
Flag number 1 is the mallet, the intimations to the mallet, the
But he was stationed in the 31st,
31st mallet. He was
31st Battalion, ITBP.
yes, madam.
So why information is given to
Mallet as
10th
because
Battalion?
the head office is the mallet, the given ITBP madam, commandant.
Maybe, but while he is stationed here,
He has been mallet attached he 31st BN for mallet arrangement of the internal security.
so during his attachment,
Yes,
he
the
is,
original posting place is the commandant Kimin man.
no, during his attachment, he should have been reported to 31st Battalion. Why report back to Kimin?
No, mallet. When he was attached at 31st BN madam, at UPA madam, this mallet the absent was found. And
No, that is besides, that is not what I'm saying. Person has come from 10th Battalion, Kimin, and attached to 31st Battalion in Itanagar.
internal board.
And during his duty in Itanagar,
madam.
he has been found to be intoxicated.
Yes.
So report should have first been given to the 31st Battalion. Why is back to Kimin?
Madam, it was attached to the internal security as arranged within the madam, the capital city madam. Then madam, attachment has to be madam, with the madam, the camp has to be at 31st BN madam.
Where does he stay? 31st.
31st madam.
So
But he is originally from the then commandant BN madam ITBP at Given.
okay. So when he is in 31st, somebody from 31st should be informed.
Therefore, madam, madam, may I take your lordships to madam, the letter forwarding of the madam, the absent report. madam. First page, madam. 15 September to the Mary, madam. With due respect, I want to say that myself, number so and so, Inspector Sunil so and so, performing is in charge of the IS duty in the same so and so. The
No. From where are you reading? From where are you reading?
I am reading internet page number 2, madam. Of page number, madam. This is to Commandant 10th ITBP. Address to the Commandant 10th BN ITBP. Given, madam. For next section.
Internal page 2. What do you say?
Madam, it is in first page, madam.
First page.
Yes, ma'am. First page. And written one.
Yes.
Omkarnath Pandey details with the IS duty. Sir, matter is that so and so Omkarnath Pandey has misbehaved many times with civilian. An individual was there has been excuse on level of so and so company manager. Company commander madam. Individual did not attend the duty and absent for the camp area on 14 September 2016 on church individual found near camp and has over intoxication. Sir, please take proper and disciplinary action against this individual. This has been forwarded to the madam, Commandant 10 PM.
Then what happened?
Then after madam, the adjutant madam, flag 4, madam, flag number 4, madam.
Adjutant of which unit?
10th ITBP. 10th ITBP, madam. Flag number 4. The office order was issued, wherein madam directed to keep the madam the petitioner under observation. Madam.
Then after that?
Thereafter, madam, accordingly, madam decided to conduct preliminary hearing, madam.
By which document?
By madam the flag number 3, madam. Order for preliminary hearing, madam. In the list of that, madam, I have given, madam.
Flag number 3.
Flag number 3 is the order, madam. It is originally in Hindi language, madam, but type copy is next page, madam.
I have already read flag number 3. Now you proceed to other flags.
Yes, madam. On 29/9/2016,
proceeded against the petitioner was held, my lord. Proceeding against the petitioner was held, my lord. Plague number 5, my lord.
Why?
Yes.
Yes.
Then after, my lord, after this, my lord,
What is this proceeding?
proceedings, my lord, if officer, my lord, if individual is found absent or misbehaved, my lord, misconduct, my lord, then proceeding has to be initiated, my lord, by the inquiry officer, something like that. Then, my lord, on 1st October 2016, 2 charges were framed against the petitioner, my lord. Plague number 2, my lord. Type copy is, my lord, next page. It is in Hindi language, my lord. Basically, two.
How have you made the flag? If you are submitting on sequence order, flag number 5, how does it come before flag number 2? Isn't it?
But, my lord, only
It should be in sequence.
my lord, now plague number 2, my lord. Kindly see, my lord, plague number 2, my lord.
After flag number 5, you're taking me back to flag number 2.
2, no, my lord, as per the
You
page.
should have gone serially. 1, 2, 3, 4 like that.
But this is the only, my lord, the mistakes done by the, my lord, as per the office, my lord, records. Next page is, my lord, basically, charges were framed against the petitioner on 2 heads, my lord. First is 21D and 43 ITBP Act, 1992.
So, was he given a copy?
Yes, ma'am.
Where is
Thereafter, my lord,
No, where is the receipt?
my lord, this is the only charge. My lord, proceedings, my lord, inquiry, something like inquiry was held, my lord, by which these charges were framed.
This is charge sheet.
Charge sheet, my lord. Actually, it is not, my lord.
Copy is never given to the charge
My
officer.
lord, there is another procedure that it has to be, my lord, the evidence, a record of evidence has to be taken, my lord.
So evidence will come later on. First of all, the person has to be know under what provision he has been charged. For what purpose he has been charged. What is the accusation?
In this charge, my lord, preliminary charge, inquiry, my lord, it has been charged under 2 head, my lord.
That I know.
Yes.
My question, specific question is, was a copy of this charge given to him?
Yes, ma'am.
Where? Where is the acknowledgement?
My lord, this is the preliminary stages by which, my lord, the investigation has to be my lord, initiated. After, my lord, after recording of also.
So petitioner is not required to be given any copy.
Yes, my lord. It is required to be given, my lord, after recording of the evidence, my lord. After recording of the evidence.
Okay, proceed.
Yes, my lord. It is in page number, my lord, the copy which they have received is page number, my lord, internal page number 25, my lord. Annex, my lord. Before that, my lord, I will come to page number, plague number, my lord, 6, my lord.
Like number 6.
Yes. Type copy, my lord, English translated is next page, my lord. Wherein, so and so, my lord, the, my lord, inquiry officer, my lord, record of evidence, my lord, officer was appointed by the department, my lord, the ITBP, or my lord, recording of the statement, the proceedings, evidence, everything is to be taken. And in the last paragraph, my lord, page, next page, my lord, it is same page, my lord. The said officer will submit the report to undersigned within 7 days after completion of the recording of evidence. And plague number, my lord, 7 is the summation of the record of evidence proceedings, my lord. Now, this is the things which, my lord, the documents which has to be handed over to the, my lord, the petitioner. In the evidence, my lord, it has been found. Record of evidence, it has been found.
What is handed over to him then?
It is, my lord, the summation of the, my lord, the report was submitted submitted to the commandant. And then after, my lord, record of evidence, next page, same like number 8.
Like 8?
Yes. Record of evidence. And the, my lord, very next page, the receipt of the copy, which has been, my lord, recorded against him, my lord.
What copy?
Copy of the, my lord, the recording of evidence and, my lord, all, my lord, documents, my lord. Record of evidence like statement and the charges, everything.
Where is that record of evidence?
My lord, the record, lordship has seen record of evidence is after plague number 8.
Huh?
Plague number 8.
Like number 8?
Yes, my lord. This is recording.
No, this is nothing. Where is the evidence?
Is my
Recorded by in
next
order of
following page, my lord.
pages.
Following page, my lord. PW1, PW2, PW3. Following pages, my lord. Up to, madam, internet page number 17, 18. All, madam, up to, these all are, madam, the recording of evidence.
Then
Then after, madam, all, madam, witnesses affirmed that he was given a change at the time.
so at what stage is the inquiry done?
Inquiry done, madam, up all recording of evidence, madam, statement, madam, if lordship see the statement.
No, recording of evidence is a part of the inquiry.
Yes, madam. After, madam, the inquiry, everything is done. It has been provided to the commandant, madam.
Then
Taking necessary, madam, the proceeding against the petitioner.
okay, where is that?
The commandant, madam.
Yes, where is the
This has been submitted to the, madam, the commanding officer, madam.
so where is the proceeding? When did the proceeding start?
Now, proceedings, my lord, once the report has been submitted before the commanding officer, my lord, then, my lord, commanding officer, lordship has seen the page number, my lord, plaque number 9, my lord. After the report, the receipt of the, my lord, the entire record of evidence, my lord, and the statement, my lord, as well. Page number, plaque number 9, my lord. Is the, my lord, constitution of the summary ports court. After receipt of the entire, my lord, documents, my lord, the summary ports court has to be constituted by the commandant, my lord. Married, man. 20th January 2017, man. Order for the constitution of the ports court was constituted by the commanding officer, man. The undertaking hereby constituted the summary ports court on 24 so and so as follows in accordance with the section 82 and 86 of the ITBP Act 1992, read with, man, the ITBP rules 1994, man. For the purpose of trial against regiment number so and so on Karnat Pandey, accused, so F company of this battalion, who is released under section 21D and 43 of the ITBP Act 1992. Malat Court, Sri so and so, commandant, presiding officer, in presence during trial, so and so person. Interpreter, stenographer, friends of the accused person, regiment manager, is particularly mentioned. Vijay Milan, friends of the accused person. Place, battalion auditorium hall.
Okay, this is the constitution of summary post.
Yes, madam. Accordingly, this was taken place, and on which, madam, plague number, madam, 10. Plague number 10, madam. Last portion. Company battalion had charged, there has been charged under section 21D and 43 of the ITBP and the 1992. And after studying the record of evidence prepared against you, it has been decided that your trial will be conducted by the summary force court. The same trial court will take place at auditorium hall, 10 battalion, police force, for the police force, district of the the following documents are being given to you, madam, for your defense as per the provisions of the Rule 65 of the ITBP Act 1994. A copy of the charge sheet, a copy of the evidence of record of evidence, along with all documents. You are informed then, in case of the failure by you to call witness other than the prosecution witness in your defense, such witness will be named by you is required to be attended to your trial. The reasonable steps will be taken in accordance with these rules to secure the attendance of the witness. During trial in the summary force court, the accused should submit the name of his persons, including the legal practitioner, the copy enclosed in Hindi or in the English, from whom he may take assistance to establishment of branch by.
Okay.
Accordingly, madam,
You may not You may not be, you may not, you're not required to read everything. You just tell me what is what, that's all.
Yes, my lord.
This is memorandum.
Accordingly, my lord.
This is memorandum. Then copy has been received.
Yes, my lord.
When?
My lord, it is 9 January 2017, my lord. Page number, my lord, next page, my lord, before flag number 11, my lord. It is in small slip, my lord.
Yes, and the translation of the slip reads 9/1/2016.
Correct.
What correct? It is wrong. It was received on 17. You have typed it as 17, 16.
Yes. After everything, my lord.
This is a typo error.
No, my lord, it is correct, my lord. After recording of entire.
What are you saying? I'm telling you, you have typed it wrong. He has received on 9/1/2017.
I'm sorry.
You have typed it as 1/9/1/2016.
Extremely sorry. Yes, ma'am.
So
In typing, my lord, it is wrongly mentioned. It is 9 January 2016, my lord.
17.
17.
When the memorandum is dated 2017, how can you give him the thing in 2016, 1 year before?
1st January, sorry, 9 January 2017 is the memorandum date.
Okay, and then what is this 15?
Then,
Eleven.
my lord, very Lordship has seen in the memorandum, my lord, he has been directed to give the name and applications for his witness, my lord. Accordingly, plaque number 11 is the, my lord, the application of the petitioner. Plaque page number 11, my lord.
Right?
Plaque number 11, my lord. Application of the petitioner, my lord. And accordingly, my lord, plaque number my lord, 12 is the proceedings of summary court, my lord. Up to my lord, page number, plaque number 13, till plaque number 13. Before plaque number 13, my lord, this is the proceeding of the summary court, my lord. Summary force court. At page number 13, plaque number, sorry, plaque number 13, arrangement, my lord. Plaque number 13, dated 24 January 2017. Wherein petitioner pleads guilty, my lord. Plaque number, my lord, 13 is the
This plea of guilt has been acknowledged by him.
yes, my lord.
Where is his signature?
Yes, sir, my lord.
Only the commandant has given a
This is
signature.
the basically proceeding. So wherein, my lord,
So commandant will write everything that he is guilty, but nobody, the person will not sign anywhere.
of course, my lord, that, not know, my lord, the copy is published. But the record here is no acknowledgement.
You tell me, what is the provision under which this kind of inquiry is conducted? ITBP Act and rules.
Yes, my lord.
What are the relevant rules?
Relevant rules is, my lord,
Yes,
the
ITBP Act.
ITBP Act.
The procedure has been prescribed in the act.
Yes.
How inquiries to be done? How inquiries to be done has been prescribed.
It is as per the, my lord, the section 82 and 86 of the ITBP read with ITBP rules. 80,
Section 82.
yes, my lord. Constitution of the, my lord, the force law.
Then charge was made under what provision?
My lord, Rule 43 and Rule 175 are very much relevant, my lordship. Rule and Rule 43 states statement of allegations.
Yes, anything to say?
Yes, madam. Thereafter, madam, plague number got seen already, the plague number 13. After 13 page, next page, very next page, madam. Proceedings on plea of guilty, madam. The recording of evidence is read, explained in the mark L, signed by the court, and announced to the proceeding. You think, madam, take the next, very next, next.
See, in your list of dates and index, you should have also mentioned the flag also.
Yes, madam, I mentioned.
You have not mentioned.
Madam, it is you mentioned page, yes, madam, plague number 13, madam.
Flag number
13, madam.
13.
Yes, page number is also mentioned, madam. 42, 40, 41, 40, 39, and 38, madam.
So plea of guilt you have shown me.
Plea of guilt is, madam, page number, madam, 40, madam. Internal page number 40, madam.
Yes, we have seen, but only there is no signature of the petitioner.
That,
No signature from the petitioner. So the authority can write whatever they want.
it is not, madam. But, madam, if we see the memorandum, madam,
Where is the memorandum? Like 10.
like 10, madam, very copy has been given to the madam, just below, madam, like 10, Hindi version, madam, English version is very next page, madam, very, 2, madam.
No memorandum that you have to give. Without giving, it's simply not maintainable. The
Copy of
your
that sheet,
proceeding.
madam, copy of record of evidence has already been furnished to the madam, the petitioner, madam.
It goes without saying. Without giving the memorandum, you cannot draw proceedings against anybody. That will have to be given.
Madam, just
What I'm asking you is, you have not, the plea of guilt has been recorded,
madam,
but where is the acknowledgement by the petitioner himself that I plead guilty? Is it not required? All right, anyway, I'll consider and pass necessary orders. Okay? I'm closing the matter.
madam, the order which the petitioner impugned is also given. Now, madam, there was one, madam, confusion regarding award of the punishment under section 51C, madam. Madam, to that extent, madam, again, may I take your lordship to the same ITBP Act, madam, for 21C. But in fact, there was little confusion, me also, madam. Page number 20, madam, section 21, I'm reading, madam. Absence without leave. D, without sufficient cause, fails to appear the time fixed at the parent or place appointed to exercise or duty or madam, the petitioner is in charge under section 21D, madam. Now, madam, last, just below, madam, after completion of the MG, madam, shall, on conviction by a court's court, be liable to suffer imprisonment for a term which may extend to 3 years or such less punishment as in this act mentioned. Now, my lord, maximum punishment is 3 years, man, or such imprisonment. Now, my lord, the petitioner has been removed from the service by virtue of this particular provision. Now, my lordship has seen 3 years or less such punishment is in this act mentioned. Now, my lord, lesser punishment, my lord, comparison, my lord, of course,
Lesser punishment is removal.
removal of. Instead of imprison him for 3 years, my lord, if section 43 is again very used, my lord, as per the section 43, it is imprisonment up to 7 years, my lord. So therefore, when is the lesser period, my lord, lesser punishment, instead of punishing him 7 years of my lord, imprisonment.
Now, supposing you punish him for 7 years of imprisonment, after 7 years is complete, then what will happen?
And automatically, my lord, the CC is removed. There is no such a way. Therefore, ITVP consider that the removal of his service from the service is considered to be the lesser period.
So, conviction and imprisonment.
It is conviction, my lord. In as per the my lord, the plague number, my lord, if again very used plague number, my lord, it is conviction, my lord. Sentence has been given.
No, whether it be for 3 years or whether it be for 7 years, after this penalty is over, you will be automatically removed.
Removed. Of course, that is not prescribed. But once the penalty, the person is therefore, removal is considered comparatively considered to be lesser punishment to the 3 years of imprisonment and 7 years.
So, direct removal is lesser.
Yes, lesser.
Instead of imprisonment, thereafter removal.
At least it could be these family and other manner. So therefore, then lesser punishment.
Of course. Want it like this now?
No.
Heard Mr. S.B. Lashkar, learned counsel for the petitioner. Mr. M. Kato, learned DSGI, for all the respondents. Hearing concluded, judgment reserved.
Highly obliged, my lordship.
Senate